It is noticed that on 9/11/2017, none appeared for the petitioners on call. Thereafter, when the matter was listed on 3/2/2020, on the prayer made by learned counsel for the petitioner, the matter was adjourned. Today, again, when the matter is listed, Mr. A.N. Ahmed, learned counsel for the petitioner, again placed for adjournment. Petitioners. This one. Therefore, as the petitioners are not interested in early disposal of the matter, now the court is inclined to issue rule returnable forthwith without requiring the petitioners to take fresh steps. This is the matter for hearing in due course.
May I please, your Lordship? Lordship, item number 11 of today's list, Lordship. Lordship, may be pleased to take up this matter after 2 weeks, Lordship.
Again, 17 matter.
Yes, Lordship, to file amendment application.
No, we are adjourning, then we will issue rule. We are not getting an out of turn hearing in matters where adjournments are sought for. On the prayer made by Miss
R.D. Kakoti.
R.D. Kakoti, learned counsel for the petitioner, matter stands adjourned today. In view of the nature of reverse raised in the present rate petition, that the rule returnable forthwith be issued without requiring the petitioner to take first steps. This is the matter for hearing in due course.
May I, Your Lordship? Your Lordship, in item number 25, I beg to mention that we are filing an additional affidavit, so kindly call for the same.
Wait, please, Your Lordship. With due consent taking from the other side, my lord, item number 49, my lord. Supplementary list, my lord. We will file an additional affidavit. So, my lordship may grant 4 weeks time, my lord.
On the prayer made by learned counsel for the petitioner, matter stands adjourned to enable to file affidavit in reply.
No, my lord, additional affidavit.
Additional affidavits in the matter. In view of the nature of dispute raised in present litigation, the address is admitted for hearing by issuing rule without return of forthwith. Same without requiring to take steps. Release the matter for hearing in usual course. Standing counsel for the Elementary Education Department and Finance is present.
Obliged. May I please, Your Lordship? I would beg to mention item number 14 on behalf of Mr. P. Item number 14 on behalf of Mr. TGF Kupona. He is out of station. 14.
40.
14.
14.
Consent has been taken.
You are taking adjournment on whose ground?
Lordship,
Who is absent?
TGF Kupona.
But this matter is not for PF Fugan. Because it is Mr. You can hire.
No, respondents.
No, he is not, his name is not there in the, show him the cause list. Show her the cause list.
SC Guwahati, I think.
Yes.
SC Guwahati.
SC Guwahati University. Guwahati University.
Guwahati University.
Okay. Let me see this item 17. 14.
14.
Mhm. So here, Guwahati University will be required. Okay. List the matter in the next week as paid for by learned counsel for the Guwahati University.
Obliged.
Next week.
May I please, Your Lordship? May I please, Your Lordship? Lordship, I beg to mention item number 38, Lordship. Lordship, I may be allowed to withdraw this matter, Lordship. Petitioner informed that he will not pursue this matter, Lordship. Item number 38.
Okay, which are duly represented? Mrs. K. Bora. Your name?
M. Sharma.
M. Sharma, learned counsel for the petitioner. Submits that she has instructions not to press the matter. According to this matter, since this is not pressed. Okay.
May I please, I
Oblige,
beg to
Lordship.
mention item 26, in the content case, the order has been complied with, Lordship, and this is the order passed on 28.
You informed Mr. Nair,
I want to say the PD Nair, Lordship.
you informed him.
Yes, yes. More, I'm for the petitioner, Lordship.
Acha,
On
you
behalf
are
of
for
Mr. PD Nair, Lordship.
Acha, you are for the petitioner.
Yes.
Okay.
So this is the order, Lordship.
Both sides are duly represented.
The
Upon
order is to
instructions,
appoint the
Mr.
petitioner.
Chetri, learned counsel for the petitioner, submits that the order in reference has been complied with. By the Director of Elementary Education Assam by order dated 28/2/2023. So accordingly, matter stands closed as the order in question has been complied with.
So in another one, in item 30, Lordship.
This copy is written on the bottom. Yes,
In item 30, Lordship, we have some times to take instruction from the petitioner, so whether the order. has been
13 is
complied with.
2017 matter,
Yes, Lordship.
13/1/3.
Lordship, 30, Lordship. Contempt case. Lordship. So we'll take instruction after 2 weeks. Lordship.
List after 2 weeks to enable Mr. Chetri counsel for the petitioner to
Petitioner.
obtain instructions.
30, oblige this.
May I please, your lordship? My lord, I beg to mention item number 16 of today's list, my lord. So this matter may be come up after 1 week, my lord. We have
Not
to,
after 1 week.
we have to obtain some instruction from our client, my lord.
No, then we are admitting it, issuing rule. Unnecessary, why should I read and come? On the prayer made by the counsel for the petitioner, the matter stands adjourned today. In view of the nature of events raised in this petition, that a rule returnable forthwith be issued without requiring the petitioner to take first steps. This is the matter for hearing in usual course.
Lordship.
Lordship, with the consent of other side, I'd like to mention item number 3. Item number 3, Lordship.
3.
Lordship, petitioner doesn't want to pursue the matter, Lordship. So I don't have any written, Lordship. Whatever take.
Both sides are duly represented. Mr. R. Sharma, running counsel for the petitioner, upon instructions, submits that his instructions not to press the matter. So accordingly, matter stands closed as not pressed.
Deeply obliged.
May I please, your lordship? I beg to mention item number 4 of daily list. Kindly pass over the matter for today, as Mr. Bhuya will not be able to present due to.
No, what this
personal
matters when you are taking an adjournment rule issue. On the prayer made by the counsel for the petitioner, your name?
A. Bora.
A. Bora for the petitioner. I say the issue rule, returnable forthwith, hearing in usual course.
May I please, your lordship? Lordship, with the consent of other side, I beg to mention item number 6, my lord. Here, my lord, petitioner number 1 is expired, my lord. And petitioner number 2's claim is rejected by the High Power Committee, my lord. So, my
But in
lord,
this case, let them.
Let the
file
matter
a
be,
petition.
a
Yes,
record may be
yes.
produced, my lord, on next day.
let the matter be taken up.
Yes.
Wait for the item number 6 to be taken up.
May I please, your lordship? Lordship, with the consent from the other side, I beg to mention item number 27 and 28 of daily list, as my senior Mr. S.K. Mehdi is out of station. Lordship, matter may be taken on 27th of March.
No. In this 2015 matter, if you are taking an adjournment, we'll issue rule and make it.
Lordship,
Hearing
on
in
the
usual
last 2
course.
occasions, the matter is not, was not raised.
I don't know, but 2015 matters, 14 matters, 16 matters, if you are taking an adjournment, then usual course. On the prayer made by the counsel for the petitioner, the matter stands adjourned today. See? Number 1, content. This is matter, usual course along with connected WPC 5202 of 2015. 2015 of October. Issue rule is visible for. Okay. No, out of time hearing when you are taking an examen in 2015-16 matters.
Lordship, just I have mentioned item number 3. Lordship may not close this matter because I don't have any written instruction from my client to withdraw this matter. So matter may take after 3 weeks, Lordship. In the meantime, I will take the instruction.
Okay, this after 4 weeks, awaiting instructions. Okay. He's received no instructions from the petitioner.
Delhi list item number
Deeply
one,
of the election.
motion be
My pleasure lordship.
Yes,
In here, the petitioner, your lordship, for 77 days he is in custody. And this is the second bail application, your lordship. Earlier it was rejected one. 21/2/2023, your lordship. Case 16 is the earlier order, your lord.
you obtained the status for the investigation instead of calling for the case diary.
My lord.
um, As the previous bail application of the petitioner was rejected. The order dated 21/2/2023 in BA 260 of 2023. The Mr. Bankim Sharma and the AVP said obtained the updated status of investigation of the case. List on. In a week's time,
My lord.
22nd March,
My lord.
22nd March.
22nd March. My lord,
Oh, sorry, not 22nd.
today is 22nd,
27th or 29th.
29th.
Okay, 29th.
Along with the medical report, your lord.
Whose medical report?
Victim guard, your lord. Since it is a case of section 7 of the.
Penetrative sexual assault.
376 is there.
Penetrative sexual assault.
76 and.
Because the girl gave statement, consistent statement everywhere. That she has been subjected to penetrative sexual assault. That is what is written in the last order.
Yes, that is there, your lordship, but medical earlier occasion, your lordship, medical report was not produced, your lordship. On the basis of the statement of the victim, your lordship, the prayer of the petition was.
Along with the scan copy of the medical report of the medical examination report of the victim.
48,
May it please your lordship. My lord, as earlier your lordship rejected it. That is at page 27. And the affair is that, my lord,
How many days
15.
today? How many days today?
is around 72 days, 71, 72. And the similar order has been passed, my lord. I have annexed page 28.
Mr. Sharma, 72 days.
My lord,
Similar order passed, my lord, page 28. And because my number was with that person, he was allowed, I was arrested. The forwarding report also says that, my lord. That I have annexed.
Page.
My lord, page 28. Same day it was rejected. Same day it was rejected along with me. my lord.
No. Where is that forwarding report?
My lord, that forwarding report is at page. Page 20 it starts. Page 21 is the ground of arrest. The below noted arrested accused person was in contact with Sunil Kumar. That was the reason. And Sunil Kumar has been allowed to go on bail. Only thing, my lord, because
We'll take it up tomorrow. In the meantime, we'll find out if the
Day after-
charge sheet is submitted or not.
day
my
after,
lord, my instruction was no charge sheet.
day after,
Day after tomorrow.
day after tomorrow.
Okay. Get information. List on sensor to enable the APP to obtain appropriate instructions. He's already there for 72 days.
My lord.
On Friday, my lord.
Day after tomorrow.
Yeah.
Thursday.
Thursday.
And my lord, item number 25, my lord, kindly take up, my lord, 2, my lord. The
Item
bail
20
hearing, my lord, scan copy is there, my lord. I will examine in the meantime. my lord.
Okay. Okay, I found him. Item 25. Some plus. Okay.
For admission, item number 6.
Six.
Yes, Mr. Goswami. Mr. Sharma.
Yes. My lord, here, my lord, petitioner number 1 is expired, my lord.
Okay.
And petitioner number 2's case has been rejected, my lord. High power committee. Yes, my lord.
But there is no reason why high power committee has been rejected.
Probably.
You have to file an affidavit so that she
Yes,
understands what is
So
the,
I can file it, my lord.
from Ms. K. Devi and counsel for the petitioner. Mr.
You, Sharma.
U. Sharma, and it's for the secondary education department. Has produced copy of copy of instructions received from the respondent authorities. And the court is informed that the petitioner number 1 had died on 19/6/2022. So the relevant counsel for the petition shall take note of this said submission. Next one, it is also submitted that as per instructions received, instructions dated 21/3/2023 received by him from the Director of Secondary Education on the case of petitioner number 2, namely Monuj Dole, was rejected by the High Power Committee. And accordingly, the claim for provincialization has been rejected. Next one. In this regard, the court directs the Secondary Education Department to file an affidavit to bring on record their stand and to enclose thereto any document on which they intend to rely on. Within a week, you will file it.
After 3 weeks, my lord, any date after
No,
3
once
weeks.
you have the record, why do you want to delay the matter? Do it within a week.
2 weeks, my lord, 2 weeks.
No, you see, you have the instructions. You just have
Yes,
to send
my
down an affidavit.
So-
What is so difficult in that? It's a 2016 matter.
16 matter.
The Leonard Stanigosi for the Education Department pays for 3 weeks time to file the affidavit in opposition. Full stop. The court does not see any reason for delaying the matter with the nature of instructions which has been provided to the Leonard Stani Council. So accordingly, that the affidavit in opposition be filed by the Secondary Education Department on or before 29/3/2023. This is the matter on 31/3/2023. The instructions produced by the Leonard Stanley Council is returned.
7.
May it please the lordship.
Yes.
Lordship, the
petitioner was a TET qualified teacher of geography. He applied in 2014. He passed the TET exam. Lordship, he applied for that in Support Higher Secondary School. Lordship, in the year 2016. But his name, he was selected and his name was in the second position, Lordship. But then the person who was selected.
Instructions in the matter. Where is the appointment letter? I have
Lordship,
not
he
found
was
it.
not appointed, Lordship. He secured second position, Lordship.
No, he may have secured second position, but I did not find the appointment letter. So without appointment letter, how you can be appointed?
Lordship, he was second, but the person who was selected the first position, who secured the first position, he has given a no objection. He got in other school, Lordship. Page number 39 is the type copy, Lordship. Now the no objection, Lordship.
Where is the employment advertisement?
Advertisement is at Lordship. Page 28, Lordship.
Instruction engagement money.
You can take it off at 2.
Yes.
Because I need the
Yes.
information as to whether this upper high secondary school,
Yes.
number one, is it a provincial high school?
Yes.
And number two, whether they had the approval of the education department to appoint the teacher in this subject. What is it? Geography.
Yes, Lordship, geography.
Whether the geography subject is concurred by the
That's what
department.
I'm asking you. There should be an approval for the appointment to that post.
Yes. Accordingly.
These are the two information we have to get
Yes.
at 2 o'clock.
Yes.
We can get the information.
Bless Lordship.
Item number 8.
Make legal process. On 29/9/2021, they took time for filing affidavit. Affidavit has not been filed. Hold on that. 8.
Where is the previous order of this court?
This case relates to my lord, drop my lord. And he's
Ah,
a
I get it,
assistant
but
teacher,
where is that order?
Anukul Chandranath, 60, page 60.
60.
Yes, my lord. Which honorable court dispose of the matter, directing to place the
Just
matter
one.
before the HIPAA committee. But
Just
HIPAA
one.
committee rejected my case, my lord, that is rejected for provincialization, my lord.
Just give me 2 minutes.
Yes.
All these matters, we are fixing it on 28th of April, correct?
Yes.
Last time also we fixed the same matter. Provincialization of the
Yes,
new,
yes, yes.
it was under the old act, now the
Yes.
new act has come in.
Yeah. Yes.
So we are listing it on the same day. Ms. K. David and counsel for the petitioner. As well as Mr. U. Shamar and his standing counsel for the secondary education department. Next. It is noted that it is seen that notice of motion was issued by order dated 21/11/2016. And despite several opportunity, the last being given on by order dated 29/9/2021, the secondary education department has not produced, has not filed any affidavit in opposition. Next paragraph. The court is upheld by the inaction on part of the secondary education department to file affidavits in time. Accordingly, as several matters of similar nature have been posted on 28/4/2023. There's this matter on the same date. Next paragraph. In the event an affidavit in opposition is not filed within an outer period of 14 days from today, the following authorities shall be personally present in court on the next date of hearing with all relevant records pertaining to the case of the petitioner. Being the Commissioner Secretary to the Government of Assam, Education Department, within bracket respond number 1, Director of Secondary Education, Assam, within bracket respond number 2, Inspector of Schools, Bongaigaon District Circle, within bracket respond number 3. Next, the standing counsel for the Education Department shall transmit a downloaded copy of this order to the authorities to ensure their personal presence in the event the affidavit in opposition is filed within time allowed.
A copy of the order.
You get a downloaded copy. You want to when they you ask the court person, give it to you.
Yes.
Item number 9.
Just add one more line. Mr. Sharma, I'm adding one more line here. It is noted with concern that in several matters pertaining to the years 2015 to 2019, the Secondary Education Department has not filed their affidavit in opposition. The Secondary Education Department is informed that they can monitor the progress of cases from the website of this court, and therefore if in these old pending cases, the Secondary Education Department does not file their affidavit in opposition, the respondent authority shall be prepared to pay heavy cost for adjournment of the matter, heavy realistic cost, which shall be recoverable from the concerned officials. This time I'm adding it here. So till 2019, if in any more cases I don't find affidavits, I'm imposing from tomorrow is the last date. Sorry, today is the last date. From tomorrow onwards at 10:30, you inform the other side, take adjournment if you want to file an affidavit. But if affidavits are not there, 20,000 per case cost I'll be imposing on the officers to be recovered from their salary. So tomorrow you have the cause list today. You ask your officials to check it up. If from tomorrow you are seeking an adjournment or the affidavits are not filed, 20,000 cost I am imposing on the officer. Today you do their homework. That is why you see, I have been informing you. Last time I also told the Advocate General And he assured the court that they are taking steps. And still in 2015, 16, 17, 18 matters, 19 matters are being adjourned just because affidavits are not there. So these officers will have to pay cost of adjournment of 20,000 per case. And since I am live there, the authorities can take note of the proceedings of the court and take steps. They can download it from YouTube and then they'll find the mind of the court.
These are the cases in where from earlier council, it is.
No, you file an FIR, you do whatever you want. You ask your officers to be there, go to the house of the earliest standing counsel, get the brief. But this excuse will not do. If you have lost the records, you know what to do. The authorities know. If you don't know, then there are books of the rules of executive instructions. You know what to do. But if from tomorrow there no affidavits are there in this education matters, first is going to come from tomorrow. Or at 10:30, inform the other side, take an adjournment. That will be permissible. But if you don't take an adjournment and allow me to open the brief, then you are liable to pay cost.
I am for the respond number 4 and 5. Challenge is regarding Constitution of Managing Committee. I think infractuous because it was constituted on 18/10/2016.
Just a moment. Yes, what is there in this matter? Is it infractuous? I think this would be infractuous.
Lordship, I think it may be infractuous, Lordship, because first, as per 1976 rules, 3 years. Here the notification did not find the period. The other notification elementary department 5 years. And it is now 2023, 2016 matter. Past meeting 16, 37. And prior number C is not applicable in this case.
In this Asimia Higher Secondary School,
Lordships, last occasion one matter, your lordship.
the teachers and the school people, they are more interested in litigation than doing what is the result this year of that school?
Information required to take lordships. And here is one matter, lordship, regarding against selection.
There are no matters. Asimia school comes every few days. Mr. Sharma, this is regarding the constitution of SMDC.
Lordship.
SMDC is constituted in how many 5 years?
As per 1976 rules, lordship 3 years.
3 years.
And present notification to the 16.
2 years.
2 years.
2 years.
Okay, what is the present act? None appears on call for the petitioner. However, Mr. U. Sharma and standing counsel for the education department, secondary education department, as well as Mr. F.U. Barbier and counsel for the private respondent is present. Next one. In this writ petition, the petitioner has challenged the constitution of the School Management and Development Committee, within bracket SMDC for short, in respect of Asimia ASIMIA Higher Secondary School Karim Branch, as well as the select list of principal dated 29/11/2016. Next paragraph. It appears that the term of the SMDC under the which rule?
1970, Assam aided higher secondary, higher middle school, school management rules,
Okay.
1976.
The Assam aided higher secondary, comma,
Assam aided
I-
higher secondary.
My lord, now it is 5 years.
yes, okay. So the Assam aided higher secondary, comma, high and middle English schools management rules, comma, 1976, comma, the was 3 years. And under the present, this is the rule now. Which is the rule now?
Lordship,
What is the rule now? Present rule?
present rule, my learned friend says there is a notification for 5 years. I do not have lordship.
He wants to take the notifications without my lord.
Okay. And presently, as per the notification number so and so dated so and so, comma, the tenure of the SMDC is 5 years. Accordingly, it appears that the tenure of the SMDC would have expired by now. So accordingly, the learned standing person for the secondary education department shall obtain instructions as to whether the tenure of the earlier SMDC has expired or not. Next one. The learned standing person for the secondary education department shall produce a certified, produce a downloaded copy of this order before the authorities to enable him to obtain instructions. This after 2 weeks. You are from?
And for the secondary, my lord.
For secondary education department. Okay, your name?
H. Terang.
H.
Terangpi.
Teranti. Okay, right her name. Let's get it back. We just give to the court person the
Yes, madam.
number. We are discussing it after 2 weeks. If the matter became first.
in
Wait, please, Lord. Matter pertains to recovery of area salary, my lord, already paid to the petitioner.
Okay.
Page 24 is the order by which my lord payment was made.
Page 24.
Yes, my lord. An amount of which 3,26,583 was paid, my lord, with due concurrence from the finance department, my lord. And thereafter, the later issued, my lord, page 26, my lord.
Just one minute. Then what happened?
Then later dated, my lord, page 27, 26, my lord, 39,
Yes.
2008. Issued by the, my lord, Deputy Inspector of Schools, my lord, to the petitioner, asking to repay back that amount, my lord.
Okay. Yes, what do you say? This is
Okay,
a area salary.
Yes, my lord.
On the last occasion, Your Lordship, Mr. R. Majumdar had produced some record, Your Lordship. I think it's in the of them, my lord. And the finance department, I believe, my lord, was asked to make a party on the last order. If you Your Lordship. So finances, probably the finance.
The role of the finance department was not clear, my lords, because this is related to excess drawal, my lords.
No, it's not excess draw.
No,
Yes.
He was
Recovery.
allotted the aerial payment with effect from 1795 to 18/6/2001.
Yes.
And therefore, instead of 326, you paid 293,
Yes, lordship.
and then you want
Recovery of entire.
recovery.
Yes, lordship. That recovery is done by the administrative department, lordship. Finance has a very limited role. Maybe we gave concurrence for the recovery, my lords. And now for wavering, if the wavering of the amount is required, my lords, again, the approval of the finance department will be required. But the proposal has to be sent by the DDO. My lords, because finance department is not the administrative authority, my lords, in this.
No. You see, look at the records, you will find that not with the concurrence of DDO, this is happening.
Lordship,
This is not happening with the concurrence of the DDO. It has just happened that the Deputy Inspector of Schools writes that the recovery be made.
yes, Lordship. So Deputy Inspector of Schools has made written the letter to the Finance Department, my lord. Maybe, and on the basis of that letter, Finance Department may have concurred, my lords, because they are not the administrative authority. Yes.
It's okay, then you.
Now, regarding wavering of the amount, my lords, if the amount has been recovered, my lords, now if that amount needs to be wavered off, my lords, it's the concerned DDO who has to send the proposal, because if the amount is above 3 lakhs, my lords, the approval of the Finance Department will be required. But for that also, there has to be a proposal sent by the DDO to the Finance Department, my lords.
So we'll direct them to do it.
Lordship?
You're allowing the writ petition and direct the authorities to do it.
Yes, Lordship, let them send it, my lords, Finance Department, and the Treasury Officer will release it upon receipt, my lords. That has to be forwarded by the DDO to the Treasury Officer.
Upon my lord, due verification.
Mr. PJ. Mr. PJ Sekal and the petitioner also heard Mr. A. Pukan Ranet, standing counsel for the Elementary Education Department,
1 to 4.
representing respondent numbers 1 to 4. Also heard Mr. A. Sharia Ranet, standing for the Finance Department, representing respondent number 5. That's correct. The case of the petitioner, in brief, is that pursuant to advertisement dated 3/9/1991, she offered her candidature for appointment as assistant teacher. And although her name appeared in the select list, the petitioner had no knowledge of the same. However, by order dated 21/5/1993, issued by the Director of Elementary Education, Assam, as well as order dated 9/7, constitutional order dated 9/7/1993, issued by the District Elementary Education Officer, Kamru Metro, within bracket DEEO for short. The petitioner was appointed as assistant teacher in Bekusi ME School. And she is currently the headmistress of Jyoti Kushi, JYOTI KUCHI LP School. Full stop. The petition claims that she is continuously receiving her salaries with effect from 19/6/2001. As well as yearly increment from the year 2001. Although she was appointed on 21/5/1993, Mr. Sayya,
My lord.
You have received salary for 2 years extra.
No, my lord.
You were appointed in 1993, but you are getting salary from 1906-2001.
My lord.
Correct.
My lord.
So you are getting salary for the period not worked.
My lord.
That means you are getting salary for the period you have not rendered service.
Yes.
Correct. So it is submitted by the learned counsel for the petitioner that she has been given yearly increment only from 2001 instead of 21/5/1993. And accordingly, according to the competent authority, wide letter number PMA 377/2005/25 dated 24/3/2006 directed leasing the release of a sum of rupees 3,26,583 towards payment of arrears salary for the period from 1/7/1995 to 18/6/2001 to the Deputy Inspector of Schools, Guwahati. First of the said communication was made pursuant to sanction received from the sanction of the conference received from the finance within bracket capital BT bracket close department wide UO number capital BB full stop 877 of the 2006 dated 13/3/2006. Full stop. In the meanwhile, budget allocation wide letter dated 28/3/2006 was made for a sum of rupees 3,26,583 issued by the respondent number 2 and placed in it is placed at the disposal of Deputy Inspector of Schools within bracket respondent number 5 before. However, a part amount of rupees 2,93,480 was actually paid to the petitioner. Thereafter, the impugned communication dated 30/9/2008 was issued by the respondent number 4 for recovery of the sum of rupees 2,93,480 on or before 15/10/2008. Next, according to the agreed petitioners filed this rate petition under Article 226 of the Constitution of India. Next now. The respondents in the elementary education department have not filed the response. Although notice of motion was issued by order dated 15/2/2017. Hence, probably what is inclined to invoke the doctrine of non-traverse and presume that the statements made in the writ petition are correct. Next, the learned study person for the finance department has submitted that although the finance department was implemented by order dated 11/1/2021, the finance department has no role in the matter, as the proposal for release of the money and the waiver, if any, will have to be done by the concerned DDO, who in this case is the Deputy Inspector of Schools, Kanpur Metro, Guwahati. It is submitted that only thereafter the finance department will take a call on the matter.
If the amount is above 3 lakhs, my lords, then the approval of the finance department is required.
Here it is more than 3.
Yes.
Next one, be that as it may. In this writ petition, the petitioner has demonstrated that she had joined a service as assistant teacher in Bethlehem MS school with effect from Nine 1993. You don't get your salary from the appointment letter. You get it only from the day you join. Correct. So here your claim is from 21/5/93. That will not be permissible. It can only be 9/7/1993. And therefore, a claim very for annual increment would be referable to the date of 9/7/1993. Stop. Yes, sir. It is also noted that where is this letter dated 24/3/2006?
my lord.
2006, from which the funds were released to you.
That letter is not there, my lord. Page 24, my lord, the sanction letter.
So see from the communication bearing memo number capital EEC -25 of 2004 177 dated 28/3/2006. That a fund of rupees 3,26,583 was sanctioned by government data number page, same page, first line, dated 24/3/2006. Page 24. Therefore, it appears that the entitlement of the petitioner for area salary, at least from 1/7/1995 to 18/6/2001, is an admitted fact. Next, where the respondent authorities have not been able to demonstrate any cogent reason for issuing the impaired order dated 30/9/2008. Order number 4299 dated 30/9/2008. Directed recovery of the amount of 293,480 paid to the petitioner out of sanction amount of rupees 3,26,583. So it has not been able, the respondents have not been able to demonstrate that any excess payment was drawn by the petitioner by fraudulent or illegal means, or that she was responsible for the overdrawal, if any. Explain. That will the matter. The court finds that the petitioner is entitled for issuance of rule in terms of the prayer made. Accordingly, the court is inclined to set aside and quash the order number 429 dated 30/9/2008 issued by the Deputy Inspector of Schools, Kangaroo to Guwahati. First, there was no stay. Has recovery been made
No
or
stay.
not made?
No still.
Not maybe.
It was not recovered, my lord. Till
Not recovered.
now.
Next paragraph. Insofar as the claim of the petitioner for entitlement of a annual increment from 9/7/1993 is concerned, the court is inclined to direct the Deputy Inspector of Schools. He is the man who will do the corrections. Kangaroo Metro Guwahati, within bracket respondent 4. We carry out the exercise of determining the entitlement of the petitioner for annual increment. And shall pass appropriate orders and forward the same to the competent authority.
After due verification.
Determine after due verification. And send to the competent authority so that the petitioner gets the benefit of yearly increment to which she may be found entitled to. First of the said exercise shall be carried out by the respondent number 4 and other competent authorities of the Elementary Education Department. Respondent number 4 within 1 month, and consequent steps will be taken by the other competent authorities of the Elementary Education Department, namely the DEEO, Kangaroo Metro Guwahati, within bracket respondent 3, and Director of Elementary Education, Assam, within bracket respondent 2, within outer period of 2 months. Next one. The petitioner shall produce a certified copy of the order before the respondent of 4. Deliver him to do the needful. Petitions are allowed to the extent as indicated above. Take a break and come back.
আজি এবার ট্রাই করিম, ঠিক আছে স্যার নাম্বার 82 কি দিলে 28 হয় না?
গাছগুলা কাটার জ্বর হয়েছে জ্বর হয়েছে I'm sorry about you. Item number 12.
My pleasure.
Yes,
It's a long pending case regarding the compassionate appointment, Your Lordship. Not considered, Your Lordship. There, page number 1 is my father's death certificate, Your Lordship.
no, by now you have already crossed the age of consideration.
Lordship.
This is a representation 2017.
Lordship.
Your age then was about 30 years. Now it is
Lordship,
17.
earlier order reflected that department has to produce some education qualification for such appointment, Your Lordship.
In this case, we had
For
filed
which my
affidavit, Lordship.
application was rejected, Your Lordship, in the year 2016, Your Lordship. My academic certificate Annexed, your lordship. Page number 6A.
You see, multiple times your case cannot be considered.
Lordship.
2010, your candidature was rejected earlier,
Lordship.
correct?
2011.
2010.
Lordship,
Subsequent.
on time rejected, your lordship. I have not
Yes.
applied within the period of 3 months.
After that, again, 2011.
Yes. Then 2015, lordship, 18/9/2015.
2011, lordship. Personals of the education qualification norms.
No, but once it is rejected after so many years, your case was rejected earlier, that was, you accepted it. So time and again, they will not consider, even now you have a good case. You can still not consider because 2010 and 11, your case was already rejected.
Okay.
It's not a mode of recruitment.
The lordship, first ground of rejection, that he is not submitted his application within the stipulated time of 3 months, your lordship, from the date of death of the employee. This rejection is immaterial, your lordship.
Pardon me?
That is 1 month, 1 year, your lordship. An additional affidavit, reply, affidavit in opposition, your lordship. Para 4 last sentence, your lordship. First para, last sentence, your lordship. Para number 4. DLC examined the proposal and rejected the application of serial number 4, Profi Ahmed, son of late Moniruddin Ahmed of this list, as he is not submitted his application within the stipulated time of 3 months from the date of death of the employee. It is 1 year.
No, even if it is
One
done
year
in
In
next
2015.
next year also, it was rejected.
Yes,
It was rejected. No.
Where is the,
Available-
what is the OM prevailing in 2010?
2010, they said 2009 OM, lordship.
2009 OM.
Yes, lordship.
It is lack of vacancy, your lordship.
2009 compassionate appointment comparison. Say. No, I have it. I have the comparison.
Number 1, lordship, in 2009 notification, lordship. Application for appointment under scheme of prescribed format should be submitted within a period of 3 months, lordship, from the date of death of the person. Clause number 1.
3 months.
Yes, lordship. In 2015, it was, lordship, 1 year, lordship, request. 2015 notification.
Yeah, rejecting your petition. For Mr. A.R. Karim, you are counsel for the petitioner. Mrs. B.D. Burman, government. Additional senior government advocate appearing for respondent number
3 lots.
E, and Mr. A. Fukan, government study person for the elementary education department appearing for respondent number 1 and 2.
4, 5, and 6.
1, 2, 4, 5, 6. Next one. By filing this petition under Article 226 of the Constitution of India, the petitioner is praying for a direction to the respondent authorities to place the application of the petitioner for compassionate appointment before the district level committee from Dhubri. Next one. In brief, the case of the petitioner is that his father, Momiruddin Ahmed, Momiruddin Ahmed, who was working as a head teacher on regular basis at 1680 number Chilki Hata, CHILKI KHATA LP School, Bilasipara, in the district of Dhubri, and died in harness on 28/11/2008, leaving behind his wife, a daughter, and the petitioner. The petitioner claims that he has passed his higher secondary examination and therefore was duly qualified for being appointed on compassionate ground, and according to on 10/10/2009, when he had applied for compassionate appointment. It is projected in this petition that the petitioner had personally visited the respondent authorities on several occasions, but his claim has not been placed before the district level committee for consideration. In terms of the judgment of this court in the case of, what is that? What is this? 2006 4 GLT? What is that?
What's the content? That's it.
Das and 2010
versus state of Assam and others. 2006 4 GLT 674 and
Fazilun Nasa and others.
2010.
Fazilun
Nasa and others.
Fazilun Nisa and others versus state of Assam and others. 2010 4 GLT 340. Next paragraph. It is noted from the affidavit in opposition filed with the respondent number 3 that the application of the petitioner for compassionate appointment was placed before the district level committee meeting held on 14/6/2010. This one. Along with the case of the petitioner, 15 other applications, inclusive of the petitioner, 15 applications were considered for the post of assistant teacher of lower primary school, Bilasipara, and the candidature of the petitioner appearing at serial number 4 was rejected on the ground that the application was not submitted within the period of 3 months from the date of death of the employee. Full stop. Although the learned counsel for the petitioner disputes the said grounds, but the learned additional senior government advocate has produced a copy of office memorandum number ABP full stop 357/80 VOL volume VOL dash Roman 1 capital /303 dated 2/3/2009. To show that as per the said office memorandum, the application in the prescribed format for appointment under the scheme of compassionate appointment was to be made within a period of 3 months from the date of death of the person. The learned additional senior government advocate has already also submitted that with effect from the year 2013,
15, Lordship.
so 15,
1/6/2015, Lordship. The
1/6/2015, the time limit for submission of the application was extended to 1 year. Therefore, considering that the petitioner may not be aware of the rejection of his candidature by the DLC in its meeting dated 14/6/2010. But the fact that his candidature was rejected by the DLC on 14/6/2010 cannot be wished away. Next paragraph. It further appears that the candidature of the petitioner was once again placed before the DLC in its meeting on 17/8/2011.
Only one vacancy is there, Lordship. 12% for that. 21%, Lordship. 5%, only one candidate.
But at that point of time, only 21 posts was 21 posts of assistant teacher in lower primary school at Bilasipara was vacant. And therefore 5% quota could be translated into one post earmarked for compassionate appointment. And accordingly, the another person, namely Mohammed Ghulam, MD, Ghulam, GULAM, Mustafa, MOSTFA, was recommended for such appointment. And accordingly, the candidature of the petitioner was again rejected for want of vacancy. Next paragraph. As the candidature, it also appears that as the candidature of the petitioner was already rejected previously, his candidature was not considered in the subsequent meeting of the DLC held on 11/1/2016.
There are found 18/9/2015, Lordship. Again, it was rejected. It was placed.
15 also, where is
Yeah.
that? Was it
Page
18 and
number
15?
3.
Okay, for the third time, for the third time, the candidature of the petitioner was rejected in the meeting of the DLC held on 18/9/2015. It is fourth time in 2016. Next one. In the considered opinion of the court, consideration for compassionate appointment cannot be a repetitive exercise. And therefore, when the candidature of the petitioner was rejected by the concerned DLC in its meeting held on 14/6/2010, 17/8/2011, 18/9/2015, and again on 11/1/2016. There cannot be a fresh consideration of the care of the petitioner for compassionate appointment. Accordingly, as the order of rejection of the candidature of the petitioner by 3 hearing before effort DLC meetings has attained finality. No, four DLC meetings indicated as attained finality, the court does not find this to be a fit case to issue any direction to the responding authorities. So accordingly, this petition fails and the same is dismissed. If no order has to cost.
Oblige.
Mr. Rahman, your matter.
Not legal also. Lordship, in this petition, I have challenged the departmental inquiry by the CKB College, York, Jorhat, my lord. And during the pendency of this case, my lord, they have dropped the charges against me, and my lord, I have been reinstated. And subsequently also, my lord, I have been promoted also. That this case, so matter maybe.
But Mr. H. Rahman, the counsel for the petitioner, Mr. S. Barwan, is standing counsel for the Higher Education Department,
1 and 7, Lordship.
representing respondent numbers 1 and 7, and Mr.
M. Smith for
M. Smith for respondent numbers.
For the college matters. 2 and 3.
2 and 3. There's no representation from the other respondents. Thanks, Madam. The learned counsel for the petitioner has submitted that by filing this petition, the petitioner had challenged the inquiry committee set up by the principal, CKB College, TO, by order dated 15/2/2017. Mr. It is submitted that during the pendency of the state petition, by resolution number 2 dated 29/2022, the governing body of CKB College, Kiyok, dropped the charges framed against the petitioner and closed the departmental proceeding. And the period of suspension with effect from 30/12/2016 to 19/7/2022 was treated as on duty. He also submits that.
Which was approved by the director.
Not the resolution, I have not been instructed about the resolution which the charges have been dropped, my lord. Can I have a copy?
No, once he says it, we are recording it.
Yes.
Even if you don't have it, he is withdrawing because it has become infectious after this.
Yes.
There's no adverse orders have been passed against you, but you
Yes.
can find it. I refer to that order.
5/12/20.
Just write that by order, by resolution to the censor. That as per that as per order under memo number DHE /CE/CC /47/2017/177 dated 5/12/2022. By resolution was censored. Moreover, by subsequent order, Under memo number, it was the second copy. DHE so and so dated 23/12/2022. On the basis of recommendation made by the DPC. The petitioner has been promoted to the post of senior assistant. Next, accordingly, it appears that the matter has become infructuous, and according to this representations, those having been rendered infructuous. You can show him that copy, Mr. Raymond.
Yes, yes, I'll give you.
15.
Looking to
Wait,
adjourn, sir.
Nicholas. Lordship, Madam, you time do for pass out timing lordship. Kegogo is different lordship. He's coming lordship. Time. For number 3 lordship. Time.
Pending.
Much.
17.
But 17 also same lordship.
Same.
Same.
Okay.
18.
Your lordship.
Yes.
In this case, lordship, the petitioner did not respond my call or messages. Very early interim order was passed on 6/9/2019, lordship. After that, there is no communication between the clients. Respondents are filed affidavit also, lordship.
Okay, Miss
M. does.
M. Das, counsel for the petitioner, submits that she has not been able to contact the petitioner and her cause has not been responded to. And therefore she pays for an adjournment. Here is allowed. Your name?
Lordship, Mr. Esbora is standing counsel of TTC. He's on
Your name, your name. You are here before me. You tell your name.
J. Rajkumari.
Learned counsel for responding number. You are for BTC.
3 and 4.
Okay, for the BTC and
1 and 2.
Mr.
1 and
As
2.
Barwar and standing counsel for higher education department, representing responding number 1 and 2 are present. Okay, list after 4 weeks.
Nineteen and 20.
Lordship, timing for my senior later the court number 20 lordship. Is the matter taken up to 10 minutes lordship?
Okay. All these laid over matters will be taken up in the second call.
Twenty-one. 21.
There is no representation of the petitioner on call. However, Mr.
I'm Saikia, my lord.
M. Saikia,
Yes, sir.
then counsel for the respondent 2
That's 1 and 2.
and Mr. U. Sharma, and then standing counsel for the respondent 1 are present. So the petitioner was previously absent when the matter was listed on 3/3/2023. Hence, it appears that the petitioner is not interested to pursue this petition. According to this petition stands dismissed from my prosecution. Please.
Twenty-two. 22.
Yes, there's an affidavit been filed in the matter.
Hello, the senior counsel is on late. But I may be
No,
passing the time.
just a minute. I'm not passing it over. Yes, you got the information.
So I'm sorry, but today I have no record. Standing counsel, Guwahati High Court is also there.
Your Lordship, my senior Mr. UK Naris on lag.
It's okay, says be here. This. You see, they are mustered of workers. They are working as sweeper in the establishment of Chief Judicial Magistrate Tinsukia. Correct. Now, the only prayer they are making is that as per the order of this court in that Table 45,
Yes, Lordship.
between us, they are entitled to that benefit. Can we allow this repetition?
Here, there are the employees of STGM Saria, my lords. Why they are not being paid, my lords?
No, they are casual workers. They are merely asking that they will be getting the minimum pay scale as per that Upen Das. As per this Upen Das.
Yes, Lordship. So respondent number 3.
2 and 3. Number 1.
2 and 3 are the establishment of Chief Judicial Magistrate.
Yes, my lord.
Number 3 is the subdivisional judicial magistrate.
Yes,
Yes,
lord.
Lordship.
The employees under those, my lordship, direction is issued to them to consider the case of the petition. That if they are entitled, my lord, depending on their service record, my lord.
Okay. Your name?
B. Talukdar.
Mr. D. Talukdar, when counsel appearing on behalf of Mr. D. Sinha and counsel for the petitioner. Also, Ms. D. Das, D. Bermont, and then additional senior government advocate
And for respondent number
appearing for respondent numbers.
1, Lordship.
Now, respondent number 1. Ms. S. Kempright, and then counsel appearing on behalf of Mr. UK Nair,
Chief
standing
Counsel.
counsel for
What's their name? And you made.
N. Just write it down here too. When counsel appearing on behalf of Mr. UK Nair, standing counsel for the Guwahati High Court, appearing for respondent number 2 and 3. And Mr. A. Shadial, and it's standing counsel for the finance department, appearing for respondent number 4 and 5. Next for that. Oh, this is a matter I can't take up. I can't take up this matter. Oh, just a moment. Is it me or excluding me? Just a moment. Oh, no. Yeah, assigned to me. Yeah, assigned to this bench. Okay. Next, the case of the petitioner, in brief, is that he was appointed as sweeper in the establishment of subdivisional judicial magistrate Sadia, Chapak Hua, within bracket respondent number 4, by order dated 9/12/1986 on a fixed pay of rupees 250 per month, which was enhanced to rupees 4,500 in the course of time. Full stop. The service of the petitioner was not regularized till date. Full stop. It is projected in this repetition that in the meanwhile, this court by its judgment dated 8/6/2017 in the case of WN number 45 of 2014, is, it's the government of Assam versus Upendas or Upendas versus government. Upendas declared. Upendas versus the state of Assam and others.
State of Assam and Upendas.
State of Assam versus Upendas. Okay.
Page number 18, Lordship.
Okay.
Page 18.
Had directed that the benefit of minimum pay should be extended to the minimum pay scale, should be extended to the casual employees with effect from 1/8/2017. And accordingly, in compliance of the said judgment, it is projected that the Finance Department, Government of Assam, had issued notification dated 8/3/2019. Notification number FEC within bracket Roman 2, bracket close 4/2014/413, dated 8/2019, page 29. By which a minimum pay scale and other benefits were provided. To stop. Accordingly, by filing this writ petition on Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities for payment of minimum pay scale of pay band 1 and grade pay of rupees 3,900, along with other admissible.
Lordship, if I may make a submission. Lordship, pursuant to this notification, Finance had issued another notification in which the house rent allowance and all were excluded, my lords. In terms of Upenda's judgment only, my lords. That notification has not been.
Okay, 3,900 as admissible. As admissible, we granted to the petitioner. Next, at this stage, the learned standing counsel for the Finance Department has submitted that there is a subsequent notification. There is a notification subsequent to notification dated 8/3/2019, by virtue of which the medical allowance,
House rent allowance.
house rent allowance, and other allowances were withdrawn. And benefits only to the extent of direction contained in the case of Upendas and others was extended to such employees. Next matter. Having heard the learning counsel for all sides, the court is of the considered opinion that in the present case, as the petitioner has been able to demonstrate that he was appointed as sweeper in the establishment of SDGM Sadia with the record respondent before, with effect from 9/12/1986. The petitioner is otherwise entitled to the benefit of the ratio laid down by this court in the case of Upen Das and others in bracket Supra. Next paragraph. In the absence of any affidavit in opposition by the respondent authorities, the court is inclined to direct the respondent number four, respondent SDGM is respondent number 3, not 4. The subdivisional judicial magistrate Sadia Chapakua within bracket respondent number 3 shall forward a proposal in respect of the petitioner for his entitlement to the benefit flowing from the ratio of the case of Upen Das within bracket Supra to the Chief Judicial Magistrate in Sukia within bracket respondent number 2, and the said authority shall process the entitlement of the petitioner and send it to the concerned authorities. So the said exercise shall be done by the respondent number 2 and 3 within a period of 6 weeks from the date of receipt of a certified service of certified copy on the respondent number 3. Stop. Consequently, the other responsible authorities shall process the claim of the petitioner and dispose of the claim within an order period of 3 months from the date of receipt of final promotion from the respondent numbers 2 and 3.
After necessary verification, Lordship.
Definitely, they will process and
Lordship,
verify.
Lordship.
Process and verify the claim of the petitioner for the proposal. Next one. In the meantime, the learned additional senior government advocate and the standing counsel to the finance department shall forward a downloaded copy of this order to the concerned authorities. So as to bring the order to their notice. Requisitions and disposal in terms of the individual law. Send them an advance copy of the order so that they'll be ready. Petition says allowed to the extent of the law. Last.
Meet please,
Yes.
Lordship. Lordship, may I pay that this matter will be taken up at 2 p.m.
At 2.
Yes, ma'am.
Nice, Lordship, the official respondents are supposed to be filed their affidavit. As per order dated 4/1/23. And the counsel for the Guwahati High Court 6 short some time to file affidavit, and on 27/2/2023, the counsel for the Guwahati High Court submitted before your Lordship that para-wise document is ready. But till that no affidavit is filed.
Okay. Mr. I have said when counsel for the petitioner submits that till date. No copy of A copy of affidavit in opposition has not been served on him. And accordingly, he presumes that the affidavit in opposition is not filed by this court. In terms of order dated 27/3/2023. Therefore, the court is inclined to proceed in the matter in the absence of affidavit in opposition. And the matter is taken up for disposal at the admission stage. Yes,
Lordship, the annex of one, Lordship, at page 19, Lordship, it is the appointment letter of the petitioner. And Lordship, the petitioner placed at serial number 5, Kamini Kumar Das, Lordship. May I read, Lordship? The under mentioned candidate selected for appointment as lower division assistant cum typist. Right,
just a moment. Just a moment. Just let me make an inquiry from the registry, because I am in a difficult position.
Yes.
Since I am also the vetting judge, I may have vetted, I don't know. Let the court must ask after some time.
Also,
19 and 20.
Where is Roshi? This matter is pertaining to recovery of excess amount Roshi. And the petitioner before your Lordship, he was the senior assistant of the college Lordship. And Lordship, their service is provincialized under the Act of 2011 with effect from 1/1/2013. And under the impending order, that is your Lordship will find at page 13.
Just a moment. Yes, we allow this repetition then.
I am appearing for the respondent number 3, principal matter.
We allow this repetition. It is not his mistake.
Hello.
But this time, handle the transfer for the petitioner. For higher education, who will be appearing?
No.
Mr. S. Excess recovery for the amount overdrawn,
Lordship.
not his mistake. Along with this, Rafiq Hasi. Mr. S. Barbar, understanding question for the higher education department. Representing respondent numbers 1 and 2. And Mr. K. R. Padgiri, counsel appearing for respondent number 3.
3, madam.
Next one. By filing this petition in the Article 226 of the Constitution of India, the petitioner has sent the communications dated 2/8/2019 and 5/9/2019, by which an amount of rupees 3,35,728 allegedly overdrawn by the petitioner was directed to be recovered in 28 installments at the rate of 12,000 per month from his monthly salary. Next, the case of the petitioner, in brief, is that the petitioner was serving as senior assistant in Jaleshwar College, JALESWAR College, Tapoban, TAPOBAN in Gwalpara district. And his service was provincialized with effect from 1/1/2013. The petitioner was being paid salary as per pay scale in the pay band of rupees 7,170 and other admissible allowances. Thereafter, by the impugned communication dated 2/8/2019, page 12, under communication number PC/Miss/77/2019/77 dated 2/8/2019. The Director of Elementary or Higher Education, Assam, informed the principal, Jaleshwar College, within record respondent number 3. The objections have been found in the scale of pay in respect of the petitioner and others. And accordingly, the said authority was the respondent 3 was directed to fix the pay of the petitioner and others in a correct manner, and also to to calculate the overall amount in a form of due and drawn statement, and to take necessary steps for adjustment of the refund to the state exchequer. Consequently, the respondent 3 by a letter dated 2/8/2019 informed the petitioner that the overall amount of rupees 3,35,724 shall be recovered, adjusted of the refund, adjusted with in 28 installments at the rate of 12,000 per month on the current month. Next one. From the affidavit in opposition filed with respondent 3. It appears that the respondent 3 has admitted that excess job was made by the petitioner. And therefore, he has justified the recovery of the overdone amount in 28 installments. Next slide. Having heard the submissions made by the learned standing counsel for the higher education department and the learned counsel for respondent 3, now the court finds that this is not a case where the petitioner was responsible for the overdrawal of his salary, or that he had committed any fraudulent act which would have benefited him of excess withdrawal of salary. Just under such circumstances, the ratio of the case of State of Punjab versus Rafiq Mansi, within bracket whitewasher, reported in 2015, bracket was 4 SCC 334, squarely covers the case of the petitioner. Next paragraph. Accordingly, the court is inclined to set aside and inquire the impugn notifications, impugn communications dated so and so. First one, number two, given number, and number two, dated so and so. On the ground, and no recovery can be made from the petitioner who is not responsible for the overall. System. According to this, restrictions are out, the extent is indicated above.
My lord, the petitioner has already retired from service on 31/1/2022. Before that amount has already been recovered. So that amount is to be returned.
No, but then you obtained an order where you did not inform the court. This court gives you an interim order not to recover.
Not to recover, that is lordship some category prior to 5 years that has been lordship.
That we don't know, you have not got it on record.
My lord, in the no recovery made in respect of any excess payment made prior to 5 years. So that amount is adjusted. But so for 5 years is concerned, that has been recovered.
In the event of no recovery shall be made in respect to excess payment made prior to 5 years.
Yes.
Next verse. The learned counsel for the petitioner has referred to the order dated, order of this court dated 29/2019, whereby as an interim measure it was directed that no recovery be made from the petitioner in respect of alleged excess payment made prior to 5 years. Rafiq Nasir, what is that suggestion? 2015?
2015. Well, I am giving that copies. 2015 4 HCC 334.
And that was given in view of interim order 18 Roman 3. Paragraph 18 Roman 3.
Yes, what do you say in that case? For refund of the amount? Okay, for that refund, you make your submissions at 2 o'clock. Because if it's a case of refund, I'll have to hear them. Okay.
Item number 20. Item number 20 is similar from same place, another senior assistant. He is still in service.
It's okay, we'll take it up then. Yes, what you call, taking consideration of the prayer for recovery. Sorry, refund. We'll take it up together.
Down in Sandeep Prasad Unyal case no way conflict with the observation made by the court in other 2 cases. In those decisions, direction was issued in exercise of power of the court under Article 142 of the Constitution. But in the subsequent decisions, the court under Article 136 of the Constitution is laying down the law, had dismissed the petition of the employee. The court in number of cases had battled with the tactic of the contours of the provisions of Article 136 and 142 of the Constitution of India. Distinctively, although the words employed under the 2 aforesaid provision speaks of the powers of this court, the former vests a plenary jurisdictions in the Supreme Court in the matter of entertainment of hearing of appeals by granting special leave against any judgment or order made by the court or tribunal in any course or matters. The powers are specific provision. The powers are plenary and to the extent that they are paramount to the limitation under the specific provisions of the appeal contained in the constitutions or other laws. Article 142 of the Constitution of India, on the other hand, is a step ahead of the power envisaged under Article 136 of the Constitution of India. It is the exercise of the jurisdiction to pass an enforceable decree or order as is necessary for doing complete justice in any case of the matter. Here, now for the paragraph 8, Lordship, my lord have kindly go to the peruse the paragraph 14 of the Sandeep Prasad Unyal case, Lordship. So Sandeep Prasad Unyal is, Lordship, next 2 pages, Lordship.
That is quoted in page 889.
889, Lordship.
That is quoted.
Paragraph 14. Paragraph 14 is quoted, Lordship. We are concerned with the excess payment of the public money, or which is often described as taxpayers' money, which belongs neither to the officers who have affected overpayment nor to recipients. We fail to see why the concept of fraud and misrepresentation is being brought in such a situation. The question to be asked is whether excess money has been paid or not, may be due to the bona fide mistake, possibly affecting excess payment of the public money by the government officers, may be due to various reasons like negligence, carelessness, collusion, favoritism, etc. Because money in such a situation does not belong to the payer or the pay. Situations may also arise where both of the payer and pay are at fault, then the mistake is mutual. Payments are being affected in many situations without any authority of the law, and payments have been received by the recipients also without any authority of law. Any amount paid received without the authority of law can always be recovered, bearing few exceptions of extreme hardship, but not as a matter of right. In such situation, law implies an obligation on the pay to repay the money, otherwise it would amount to unjust enrichment. That particular principles of law laid down in the Unyal case was framed by the 3 judges bench of the Honorable Apex Court in Lordship Rafiq Masih's case, Lordship. That particular principles was framed by the Honorable Court, Lordship. Paragraph 8, Lordship. Even, Lordship, the head notes also, Lordship, in internal page 885, Lordship. 885 reflect that Sandeep Prasad Unyal versus State of Uttarakhand so framed, Lordship. Then, Lordship, the 2 judges bench of Honorable Apex Court Rafiq Masih itself says that, Lordship, the recovery in cases, the recovery from the employee when the excess payment has been made for a period in excess of 5 years before the order of the recovery issues, Lordship. We cannot recover beyond the, as per the law laid down by the Honorable Apex Court 2 judges bench of the Rafiq Masih. We cannot, Lordship, recover beyond the 5 years period, but we can, Lordship, recover within the 5 years period, Lordship. As per the principles of law laid down by the Unyal case, Lordship, we can recover, Lordship, whole amount, Lordship. And that was also, Lordship, framed by the 3 judges bench of the Rafiq Masih's case, Lordship.
Okay,
Lordship.
okay, this part I will consider and pass over this. You have anything to say?
Lordship, in the, when we argued the case, Lordship, we have not bring the notice of the full range judgment of the Rafiq Masih's case, Lordship. It is the one issue is also there, Lordship. Now I'm blame ourselves, Lordship. But the Rafiq Masih's 3 judges bench specifically mentioned that, Lordship, the order passed under Article 142 of the Constitution of India, 1 steps ahead under Article 136, Lordship. Even the Unyal case was passed under Article 142 of the Constitution of India, and that particular observation made by the Honorable Apex Court in Unyal case was framed by the 3 judges bench of the Lordship Rafiq Masih's case.
Okay.
Oblige, Lordship.
That part, last the issue of the recovery, I'll just
Lordship.
go through it and pass over this.
Lordship, Lordship.
But after the interim order, Lordship, there was a Lordship in first case, Lordship. 12,000 was Lordship directed to be adjusted, Lordship. After the interim order, Lordship, the 7,000 amount has been adjusted, Lordship. After the passing the interim order, Lordship, the 12,000 has been reduced to 7,000, Lordship. So 7,000 per month was adjusted, Lordship.
7,000 per month instead of 12,000.
12,000. In the first case and in the second case, Lordship, 4,000 was per month. That was reduced to 2,500.
12,000 was reduced to 7,000 after the interim order. Second case, it is from 4,000 to 2,500.
2,500.
Apply, Your Lordship.
In second case, lordship, the petitioner is still serving.
Second case, petitioner still serving. I'm returning you.
Lordship. Apply, Your Lordship.
Obliged.
Thank you. Yes, 25.
25.
My lord. At the outset, my lord, I must tell your lordship, my lord, after rejection of the bail application, the petitioner approached the apex court, but he has withdrawn. And that order I have annexed, I bought it by means of an additional affidavit. Now, be that as it may, my lord, today is 217 days. And the matter is fixed at the stage of commutal. Now, my lord, out of the 10 FIR name accused, if your lordship kindly comes to page number 15.
Where is the order of the Supreme Court?
Supreme Court additional affidavit, the first page number, since it is a running page, my lord, so it would be page number 104. Additional affidavit which we have bought on record today, man. Page number 104.
That is not here. Give me a copy.
My lord, this is, I'll give you.
Let me ask you one question. How many days today?
217 days, my lord. Now, my lord, out of the 10 FIR name accused, 8 are on bail, 1 not charge sheeted, and the 10th one is before your lordship today. If your lordship sees page
Eight charge sheeted.
8 FIR name accused are on bail who are charge sheeted, including the present petitioner, who is the 9th one, who is not on bail, and the other one against him charge sheet has not been filed. So, save and accept the present petitioner, all the FIR name accused are on bail, madam. Page number 15, my lord, and the allegations are similar, my lord, against all the accused person. No overt act is attributed to anyone, either in the FIR or in the charge sheet, my lord. Page number 15, if your lordship kindly comes, my lord. Page number 15, your lordship is there, my lord.
Just only.
My lord.
Where is the previous order?
My lord, previous order, your lordship will find at page number 32, my lord.
Okay.
My lord, kindly see the page 35.
Yeah, just a moment. Mr. Vishwas, which page you wanted me to read?
Page number 15,
51.
15. FIR. My lord will see the list of the accused person. 1, 2, 3, 10. Now, except one from accused number 2 to 9 are all on bail. 10 against 10 charge sheet has not been filed. And if I read the FIR, my lord, no special act is attributed to anyone.
Do I mean that this is the culture in our country
My lord.
that before somebody attacking someone, they give a visiting card, give their identity card to the others, ask them to write names and then attack.
Absolutely, my lord. That is why, my lord, because I was about to submit that even in the charge sheet, that is after investigation, the opinion of the page number 28, there is no special attribute to anyone. Even in the FIR, even in the charge sheet page number 28, if your lordship comes, the brief fact of the case, which starts from page 27 and 28, the page 28, para 2, the opinion of the IO after investigation, in due course of investigation.
Yes.
Now, my lord, one additional fact, my lord, the wife of the petitioner has given birth to a female child on 18th. On 18th. And I have annexed in that additional affidavit which I have filed today morning, my lord, I have annexed the relevant medical report, my lord, which indicates that his wife has given birth. In fact, while I filed this bail application, I have annexed the pregnancy medical reports, my lord, but on 18th, she has already given birth to a female child, my lord.
Okay.
And
yes.
And my lord, the case is yet to be committed on 24th, it is fixed, my lord. There are as many as 40 listed witness. If your lordship see page number 25 of the charge sheet. Particulars of witness cited. There are as many as 40 witnesses, my lord.
Okay. You are referring to page 30?
My lord.
You are referring to which page?
Yes,
30?
my lord, your lordship ordered it, my lord, order, my lord, page 35, para 7, my lord. And my lord, the next page also, my lord. And my lord, regarding identification, my lord, that all the people belongs to the, my lord, same locality. Your lordship observed that in page 36, my lord. Well, that's why, my lord, they have known each other, my lord.
But all of this were released on bail.
Yes. Yeah, that is there, my lord.
Why should only one be left out?
Yes.
Yes, 25 should be said. No, it's just symbol. Become citation, question of Google, and no this citation belongs to the mobile in the yes, I will have my all of this problem there. And so the evaluation system is there. Left over file to the virtual device.
And I have gone through to my lord, scan copy. I have landmark all the 11 pages, my lord. 164 statement of my lord injured person, my lord. All are implicated, my lord. Opacity is there, my lord. But,
So the only consideration is that if they should still commit to stage.
yes, my lord.
My lord, with any stringent condition, my lord.
Mr. Sharma,
My lord.
something in the case, seen something in the case diary. I would like a clarification from you.
My lord.
At 4:30, please come in the chamber. I'll just ask you questions. I will not ask in the open court.
My lord, my lord.
I consider in pass already. I have a clarification to take from the APP.
My lord will only consider that all the accused persons similarly.
I've taken note of that.
He's having an infant 2 or 3 days back, my lord, an infant, my lord.
Lordship, I
Nobody
appear
to
for
look
the
after
informant.
The
Lordship.
boy is also.
Appear for the informant.
You're for the informant.
Lordship.
Yeah.
The order rejection Lordship has clearly depicted that he did not follow Lordship's order. NBW was issued, that was
No,
suspended.
that is, you see, that is one part.
Lordship.
He did not appear before the court. He was granted bail. He did not appear. For that conduct,
Lordship.
but the fact is that he was considered for bail at one point of time. And the second is that if all the accused persons are on bail, why to single out a individual?
Lordship. Your Lordship.
There is some element of consideration will come in, but there's a clarification I have to take. Since you being the defense counsel, you are here, I'll just ask him in the chamber.
My lord, just to clarify what my learned friend has said, it is not that he was on bail and he did not go and appear. There was a warrant of arrest, it was suspended and he was asked to appear with it. So he was not on bail that he did not appear, but again, my lord, at the end of the day, he voluntarily surrendered. He was not arrested from any place, my lord. I'm deeply obliged.
Obliged.
I'm deeply obliged.
May I please give? I have received the instruction here, my lord.
Yes.
Here, my lord, the petitioner has not joined his service during 15 days period, and moreover, he has not joined the service. And it was lying vacant. Thereafter, one Mr. Biswajit does join in his service as that qualified candidate on 24/5/2022.
When you file an affidavit, he has to know about it.
Yes, ma'am. Yes.
Correct.
Yes.
We don't need an affidavit. Mr. Your name I forgot. You Sharma, lawyer counsel for the petitioner, is present. Mr. U Sharma, learned standing counsel for the secondary education department, has submitted that he is in receipt of instructions, written instructions, according to which the petitioner did not join service at Chapel HS School within the 15 days time allowed, and thereafter another candidate was allowed to join service on 24/5/2022. Next one. He knew the
Mr. Biswajit Das was joined.
yes. I said one candidate, we had it. Next one. Accordingly, the court is inclined to direct the respondents in the Elementary Education Department,
Secondary education.
oh, sorry, Secondary Education Department to file their affidavit in opposition within 2 weeks from today. That's why we respondents in the Secondary Education Department shall take notice that on failure to file an affidavit shall invite imposition of cost or rupees 20,000 on the jointly and severally on the respondents. It shall be ordered to be recovered from the salary of the said respondents. Next, the affidavit shall be filed within 2 weeks will be within 5/4/2023, list on 10/4/2023. Next, for the London Standing Council for the Secondary Education Department shall transmit a downloaded copy of this order to the respondent authorities. Instructions produced today is returned.
23. 23. 23.
Yes.
While the counsel for the other side has just informed us that he has got to matter, he doesn't have any colleague. He has gone to court number 20. In the meantime, I can start. But on the last occasion, when the matter was called up, your lordship directed to find out as to whether the original will was actually submitted or not. Now, records were called for from the record. If we have obtained a copy also on 6/12/2017. In the order sheet, it is mentioned, my lord, keep the original will in the safe custody of the court. That means the record in the original will was submitted now. My lord, your lordship is aware of the text of the case. We should.
No, just remind me because I'm so
My lord,
so forgetful.
and we are for the petitioner in a probate petition.
Huh.
Will was exhibited. 2 attesting witnesses were examined. In their examination in chief, they said the will was executed in our presence. During cross-examination of both these witnesses, a question was put as to whether you have said or the signature of the testator was exhibited or not. They said no. Thereafter, an application was filed under 151, not under order 18/17, for recalling them. Basically, prayer was that for additional evidence, basically, unless they are recalled, there is no question of filing additional evidence. So that was allowed by the court below by exercising their discretion. And then a revision was filed before this honorable court challenging that. And this honorable court allowed the revision petition, holding that it was for filling up lacuna. Thereafter, the matter was taken to Honorable Supreme Court. On Supreme Court said you better file an application for review before the Honorable High Court. That is how we have filed the High Court. This is the position. Review application we have filed. Now, I am on a very limited campus. Normally, yes, my lord, that your lordship is relied. I'm just before I make my submission, my lord. The division bench judgment passed by your lordship, reported in 2000. 21 volume 3 GLR page 389. I'm just handing over a copy, my lord. And I'll just read one paragraph from that judgment and I'll make my submission.
Give the citation again, Mr. Rajendra.
My lord, I'm handing over a copy, my lord.
No, sorry, just
2021 volume 3 GLR 389 Musammat Neil Bhan versus Union of India. It was a division bench judgment, but then authored by your lordship.
Yes.
My lord, I straightway go to paragraph 13 and 14. May I read, my lord?
Yes.
Para 13. The matter relating to petition number so-and-so is taken up now. In this regard, we have already indicated above that the trial before the learned tribunal was concluded and case was fixed for argument, and at that stage, petition number so-and-so was filed. We are of the considered opinion that it is too well settled that power under order 18 rule 17 CPC cannot be used to fill up any omissions in evidence of witnesses who had already been examined. The said provision is only meant for recall of witnesses for further examination chief or cross-examination, or to place additional material or evidence. The court may permit a party to recall witness or fresh evidence where application is bona fide. Leading additional evidence, oral or documentary, would assist court to clarify evidence on issues. Such measures would assist the court in rendering justice, and if court is satisfied that earlier non-production was for valid and sufficient reasons. If these conditions are not present, it would be open for the court to not entertain such petition. The power available under Order 18 Rule 17 CPC is discretionary and should be used sparingly. If such power is used in a routine manner, it would defeat the very purpose of various amendments made to CPC for speedy trials. The said power can be invoked by the court to clarify doubts, if any, about evidence so that it can put questions and elicit answers. If one requires any authority on the said point, the case of Gayatri versus Girish, reported in 2016-14 SCC 142, may be referred to. In the present case in hand, we find that the petitioner is seeking to introduce evidence by recall of witness, which was already available at the time when defense witness were examined. The documents as indicated herein above are neither new evidence sought to be introduced nor new facts discovered subsequently. Thus, it is apparent that only after cross-examination of the witnesses that certain lapses in the evidence of the petitioner's side was noticed. The main purpose of Order 18 Rule 17 CPC is to enable the court, while trying a case, to clarify any doubts which may have with regard to the evidence led by the parties. The said provisions are not intended to be used to fill up omissions in the evidence of a witness who has already been examined. If one requires any authority on the point, the case of Vadiraj Nagappa Varnekar versus Sharad Chandra Pravakar Ogate 2009 4 SCC, my lord, has been referred. Now, in the earlier paragraph, in paragraph 13, my lord, your lordship has referred to that Gayatri's case. And in Gayatri's case, I have brought a copy of the Gayatri's also. Gayatri's case has relied actually in the original judgment of Belusami. Your lordship is aware of that, but in many cases it has been referred. That is 2011 is Gayatri or Belusami. No. Gayatri.
For 3 months, I was in a bench where there's no nexus or close proximity with civil.
Just for a change, my lord. Well, 2000.
All these bail matters made me a dull boy.
Well, 2016-14 SSC 142 is the case of Gayatri, which
Yes.
your lordships in the division bench referred to. And in para 7, my lord, lordship will kindly see KK Velusami's, and in fact, my lord, the wordings your lordship has used is actually the from KK Velusami. It's not quoted here. I'm not taking your lordship to this Gayatri because this judgment is again clearly quoted in paragraph from Velusami. So I'll go to Velusami directly.
Plagiarism.
To some extent, but this plagiarism is permitted. Minus. It falls in the legal plagiarism. Well, this judgment of 2011 SCC, or you may kindly see 2011 volume 11 SCC for my learned friend 275. Now, this was a case of specific performance of contract, my lord. And in this case also, at the stage of argument, an application was filed seeking to get a permission to recall the witness to prove that subsequent to the stage of examination of witnesses, particularly these witnesses, there was a outside court conversation with some other friends in which he had admitted that yes, as the defendant has taken a stand in this case, the owner of the property, that the money he has taken was not actually in advance for the entire consideration to sell the plot of land, but it was simply a loan. These conversations, the applicant therein recorded in a compact disc. And for introduction, by way of additional evidence, finally, he filed the application for recalling the witnesses. It is in that background manner what the Honorable Supreme Court has said. I'll take the lordship to one particular paragraph. I'll be referring to para 9 and para 19. Para 9 I'm reading first. Is the lordship got para 9?
Yes.
Order 18, Rule 17 of the Code enables the court at any stage of a suit to recall any witness who has been examined, subject to the law of evidence for the time being in force, and put such questions to him as it thinks fit. The power to recall any witness under Order 18, Rule 17 can be exercised by the court either on its own motion or on an application filed by any of the parties to the suit, requesting the court to exercise the said power. The power is discretionary and should be used sparingly in appropriate cases to enable the court to clarify any doubts it may have in regard to the evidence led by the parties. The said power is not intended to be used to fill up omissions in the evidence of a witness who has already been examined. Again, that Vadiraj case has been referred. Order 18, Rule 17 of the Code is not a provision intended to enable the parties to recall any witness for their further examination in chief or cross-examination, or to place additional material or evidence which could not be produced when the evidence was being recorded. Order 18, Rule 17 is primarily a provision enabling the court to clarify any issue or doubt by recalling any witnesses either suo motu or at the request of any party, so that the court itself can put questions and elicit answers. Once a witness is recalled for purposes of such clarification, it may, of course, permit the parties to assist it by putting some questions. Paragraph 11 also, you kindly permit me to read, I didn't say initially. There is no specific provision in the code enabling the parties to reopen the evidence for the purposes of further examination in chief or cross-examination. Section 151 of the code provides that nothing in the code shall be deemed to limit or otherwise affect the inherent powers of the court to make such orders as may be necessary for the ends of justice or to prevent the abuse of the process of the court. In the absence of any provision providing for reopening of evidence or recall of any witnesses for further examination or cross-examination for purposes other than securing clarification required by the court. Kindly see. For code, the inherent power under section 151 of the code, subject to limitations, can be invoked in appropriate cases to reopen the evidence and or recall witnesses for further examination. This inherent power of the court is not affected by the express power conferred upon the code under Order 18, Rule 17 of the Code to recall any witness to enable the court to put such question as to elicit any clarification. The respondent contended that the section 151 cannot be used for reopening evidence or for recalling witnesses. We are not able to accept the said submission as an absolute proposition. We, however, agree that the section 151 of the code cannot be routinely invoked for reopening evidence or recalling witness. The scope of section has been explained by this court in several cases. The cases have been referred to. Now we can avoid this matter. Now only para 19, madam. I'll trouble your option.
Yes.
We may add a word of caution. The power under section 151 or order 18 rule 17 of the code is not intended to be used routinely merely for the asking. If so used, it will defeat the very purpose of various amendments to the code to expedite trials. But where the application is found to be bona fide and where the additional evidence, oral or documentary, will assist the court to clarify the evidence on issues and will assist in rendering justice, and the court is satisfied that non-production earlier was for valid and sufficient reasons, the court may exercise its discretion to recall the witnesses or permit the fresh evidence. But if it does so, it should ensure that the process does not become a protracting tactic. The court should firstly award appropriate costs to other party to compensate for the delay. Secondly, the court should take up and complete the case within a fixed time schedule so that the delay is avoided. Thirdly, if the application is found to be mischievous or frivolous or to cover up negligence or lacuna, it should be rejected with heavy costs. Now, there are 22 maybe of some relevance. Ultimately, what was done in this case. In this case, we are satisfied that in the interest of justice and to prevent abuse of the process of court, the trial court ought to have considered whether it was necessary to reopen the evidence, and if so, in what manner and to what extent further evidence should be permitted in exercise of its power under section 151 of the code. The court ought to have also considered whether it should straightway recall PW 1 and 2 and permit the appellant to confront the said recorded evidence to the said witnesses, or whether it should first receive such evidence by requiring its proof of its authenticity and only then permit it to be confronted with the witnesses PW 1 and 2. In view of the above, these appeals are allowed in part. The orders of the High Court and the trial court dismissing IA number so under 151 of the code are set aside. The orders are affirmed in regard to the dismissal of IA number so under order 18 rule 17 of the code. The trial court shall now consider IA 21620 of 2009 afresh in accordance with law. And my submission before Lordship is very limited in view of this legal propositions related, but the
Just a minute.
man.
What is this IA 216?
216 is the IA under 151. It is mentioned in this paragraph, it's 23 itself, man. Under 151, man. For reconsideration of the application under 151, in the light of what has been stated.
6 is 151.
My. And so far as the rejection of application under order 18 rule 17 is concerned, that was affirmed even by the Honorable Supreme Court.
Yes.
In the light of the propositions laid down in this case, my submissions before Lordship are basically twofold, my lord. My lord, I'm pushed to the wall, my lord, that is why I have to. And here is a case, my lord, the original will was submitted, original will was exhibited, and in the examination in chief also we have clearly stated these two witnesses, we mean these two witnesses, my lord, 2 and 3, PW 2 and 3.
Yes.
They have clearly stated that the testatrix executed the will in their presence.
Yes.
My lord, only omission that crept in the whole process is that the signature of the testatrix was not exhibited. Exhibit mark was not put in the signature. Otherwise, they have clearly stated, and in the cross-examination, I'll show just now to your lordship. In the cross-examination, it could not be demolished. This evidence that the execution by the testatrix in their presence was not demolished. It was only extracted in the cross-examination that you did not exhibit the evidence. My lord, I would like to just distinguish between a lacuna and my lord. My lord, in my humble submission, my lord, subject to consideration by your lordship, lacuna and pure and simple omission to bring an evidence in support of my case is one thing.
Yes.
And an omission to mark the signature of the testatrix as exhibit is a conditional omission in my humble submission, my lord, directly attributable to the technical error committed by the conducting counsel. And it is not a case where the witness doesn't say that the testator executed or put the signature in their presence. It's a pure and simple case where it's a error on the part of the conducting counsel. Maybe the senior was not present, junior was present, and I was very fresh junior. We don't know, my lord, but then it is purely in the realm of conduct mistake committed or omission committed because of the maybe ignorance on the part of the conducting lawyer. Had it been a case where the signature was not there, or we did not say that signature was the testator did not execute it. Now I want to introduce a witness and examine him for the purpose of proving that no, it was executed and signed in the presence of the witnesses. That would be a case of filling up of lacuna. Now, if I am clear about the distinction I am trying to make, then my lord, in view of what has been ultimately said by almost Supreme Court in para 19, and your lordship also relied in the independent judgment, three things come out from that the paragraph 19, my lord. That the first of all, the application has to be bona fide. And here, neither the other side is saying, nor it is coming out from the records that we were not bona fide in filing the application. Second, it says, my lord, it will assist the court in rendering justice by clarifying. Here is a case, my lord, your lordship is aware that Supreme Court judgment which says the intention of the testator or the testatrix is the ultimate object which the honorable court will always, my lord, honor. And I've got the judgment, I'll just show my. Now, here is a case, my lord. Omission, if any, was directly for the mistake of the lawyer, and it was not a case of any omission or lacuna on the part of the petitioner in my lord, fulfilling the requirements of law. The law says, my lord, there should be two attesting witnesses, unless one is unavailable or dead. Both of them should be examined. Your lordship is aware of that. That is the law. So, first of all, my lord, it was bona fide. Secondly, I'll answer questions. If your lordship possibly is trying to put some question to me, I'll answer all this one. I'm just showing three things colored from there. One is it has to be bona fide. Secondly, it says it will assist the court in rendering justice by way of a clarification. The clarification, in my humble submission, necessary in this case is maybe the court itself will put a question to me.
Just give the point, number one.
Number one, the application, whether the application was bona fide or not, filed by us. Number two, my lord, whether the said process now, if permitted, will assist the court in rendering justice by way of a clarification through this PW 1 and 2 and 3.
Yes.
And this, my lord, here the language used is non-production of such evidence earlier was for valid and sufficient reason. My humble submission, my lord, as I have stated, it was purely a mistake committed on the part of by the lawyer. And that is why there is a valid reason for not exhibiting the signature of not putting the exhibit mark in the signature of the tested things. And lastly, my lord, the Honorable Supreme Court has said if the application is frivolous or to cover up negligence or lacuna, then it should be rejected. My humble submission before your lordship is this is absolutely not a case of frivolous petition. And it was not negligence or lacuna on the part of the petitioner as such. It was a pure technicality which only the lawyer will know and the petitioner is not supposed to know. That's my humble submission your lordship will consider. I am now praying not for a review of your lordship judgment and to allow my application. What I'm saying is, my lord, these conditions to some extent I'll admit. The learned court below, while allowing the application, has gone into one aspect of the matter and exercised its discretion, my lord. But these considerations, which I say, my lord, according to Supreme Court, should be the consideration. Your lordship may consider whether the matter can be sent by setting aside the order. Matter can be sent back to the trial court to consider these issues, my lord, and thereafter take a decision as to whether they should be permitted to be recalled, either under Order 18 Rule 17 or under 151, my lord. Because 151 in paragraph 11 of this judgment, my lord, has said that in a case not covered by Order 18 Rule 17, possibly in a given case for for the interest of justice, 151 can be sparingly exercised. And I'll show the judgment where the Honorable Supreme Court says that the intention of the testator should be given weightage. Well, I'll just give the judgment, man. Other side may in the meantime argue.
Mr. Mazumdar, the only question I was trying to ask you is, you see, in every trial, whether it be civil, criminal, or before any other tribunal, it is normally a lawyer who holds the brief. And not in one case, but sitting here in civil side and criminal side, I've seen that the so-called mistakes which are procedural in nature is not limited to one or two cases. It's multiplying like anything now.
The lordship is absolutely correct.
The impression which I'm having, subject to all respect to the members of the bar, is that on procedural law,
They should be careful.
no, not careful. The extent of knowledge itself is questionable. So far as CPC is concerned, so far as the criminal procedure code is concerned,
Lordship is absolutely
the
correct.
third part is the people have a section of young generation of lawyers have forgotten civil code rules and orders and criminal code rules and orders.
Whether it is there or not.
Yes,
many,
it's
many will
forgotten.
not. I've understood.
And the memory is triggered when somebody behind you has come. A memory has been triggered. It was only late J.N. Sharma, when he was senior counsel then. He would not appear in a court without civil code rules and orders in his hand. His juniors would mandatorily have it, and then only he would enter the courtroom.
Those things will have to be reintroduced again, my lord.
That is the only example I can give.
Absolutely. In fact, yesterday, I was arguing one election case. That was a case of, again, non-disclosure of all the assets and sources of income in the Form 26 of the nomination paper. Now, there was a mistake in mentioning the name of the vehicle which was not disclosed. It was AR 11-2446. But somehow, as your lordship is saying now, AR 11A was missing. But there are other materials and there are a lot of ample evidence to show that it is the same vehicle. And interestingly, the The respondent by filing written statement has also admitted that yes, this belongs to me, but I did not mention it in the form 26 because of this reason. He has given a justification. Now, just to clarify that it is the same vehicle, it took me around 1 hour to show other materials. Then the court paused for a moment and said, see, for one small typographical error, you have taken 1 hour of court's valuable time. This.
Yes, Mr. Mokit.
May it please your Lord. My Lord, this is a review application. And what appears from the review petition and what was being submitted before the Honorable Supreme Court, that the first error, according to them, was that the notice was not served upon them. Because in the order dated 13/3/2020, the first two lines says, that heard Mr. Z. Mukit, learned counsel for the petitioner. Page number 78.
Yes.
Page number 78, annexure N, my lord. The
Yes.
first two lines says, heard Mr. Z. Mukit, learned counsel for the petitioner. None appears on call for the respondents, although the notice on them was duly served. According to them, it was not duly served, so it is an error. That is one ground, my lord. The other day, your lordship had taken the pain to go through the records, and it was found that the notice was duly, in fact, served. So that point goes away, my lord.
It is
Second,
served, it is not served.
it is served.
It is served.
Your lordship had scrutinized the entire records of the revision petition. Then.
Is this a case from Guwahati? No.
It's a case for Guwahati.
Guwahati.
Mr. Mukit and wasn't that?
Problem is audio, I'm not.
They're not hearing us. I know them well.
I just find it from.
Huh. Voice from this side is low.
Lower.
I'll request some more time because he's not picking up the phone right now.
Okay.
So it may take after 10 minutes. In the meantime, I'll find out. The old man was 74, 75 years.
Oh, no, no, then it can't be. Then it can't be.
He's more than 74.
No, because the man I'm speaking of is my classmate.
No, he's
No.
more than 74.
Then it's not there. Okay.
If may I
You
continue,
have
my-
proceed.
My lord, I was on that point of notice. For that, your lordship, office note dated 2012-2018 of CRPIO 39607.
Yes, service is made.
Service is
Okay.
made. Now, that is one point that they had raised to be an error on the face of the record. Thereafter, I have seen all the grounds. There is no such ground assailing this order passed by your lordship containing any error which is apparent on the face of the record. Now, what the arguments that has been advanced by the learned senior counsel is it appears that the order which is passed by your lordship suffers from errors. Now, that is not within the review jurisdiction, my lord. That jurisdiction is of the higher court. Only in case where there is an error apparent on the face of the record, and it must be not by way of reasoning, my lord. Not by way of reasoning, but must be apparent. That is what the Honorable Supreme Court has judged in the case of Parson Devi, that your lordship knows, 1997 8 SCC. Page 715, para 9 and 10, my lord.
Para
9 and 10.
9.
9 and 10. I may read. Under Order 47, Rule 1 CPC, a judgment may be open to review inter alia if there is a mistake or an error apparent on the face of the record. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its power of review under Order 47, Rule 1 CPC. In exercise of the jurisdiction under Order 47, Rule 1 CPC, it is not permissible for an erroneous decision to be reheard and corrected, my lord. So that was the last leg of argument that the senior counsel had made, that I'm not asking for an actual review. Let the matter be remanded, my lord. For that, your lordship has to hold that there is some error on the face of the record which requires a review, and then the case can be reopened and reheard on merits, my lord. Not before that, my lord. A review petition, it must be remembered, has a limited purpose and cannot be allowed to be an appeal in disguise. Considering in light of this settled position, we find that Sharma J clearly overstepped the jurisdiction vested in the court under Order 47, Rule 1 CPC. The observation of Sharma J that accordingly the order in question is reviewed, and it is held that the decree in question was of composite nature, wherein both mandatory and prohibitory injunctions were provided. And as such, the case was covered under Article 182 and not Article 181, cannot be said to fall within the scope of Order 47, Rule 1 CPC. There is a clear distinction between an erroneous decision and an error apparent on the face of the record. While the first can be corrected by the higher forum, the later only can be corrected by exercise of the review jurisdiction. While passing the impugned order, Justice Sharma found the order in civil revision dated 25/4/1989 as an erroneous decision, though without saying so in so many words. Indeed, while passing the impugned order, Justice Sharma did record that there was a mistake or an error apparent on the face of the record, which was not of such a nature, which had to be detected by a long drawn process of reasons, and proceeded to set a not the order of Justice Gupta. However, mechanical use of statutorily sanctified phrases cannot detract from the real import of the order passed in exercise of review jurisdiction. Recourse to review petition in the facts and circumstances of the case was not permissible. The aggrieved judgment debtors could not have approached the higher forum through appropriate proceeding to assail the order of Justice Gupta and get it set aside, but it was not open to them to seek review of the order of Justice Gupta on the ground details in the review petition. In this view of the matter, we are of the opinion that the impugned order of Justice Sharma cannot be sustained, and we accordingly accept this appeal and set aside the impugned order dated 6/3/1997. So the review petitioner, my lord, has failed to point out any other, or in fact, any error which is self-evident on the face of the record of order dated 13/3/2020 passed by your lordship. Now on the point regarding the point of approaching the court under section 151 to recall the witnesses, that your lordship, it is settled by that K.K. Veluswamy judgment reported in the year 2011 that it can be done under 151 because under order 18 rule 17, my lord, that is only the court can exercise the power. No party can make any application under that rule. So only under section 151 an application can be filed. Now, if your lordship would see in the present case, what the what the review petitioners had done, my lord, for that I would take your lordship to your lordship's order dated 13/3/2020, paragraph number 8. Yes. If I may read paragraph 8 of your lordship's order. In this regard, it is seen that while passing the impugned order, the learned trial court has failed to appreciate that PW2 and PW3 were both cross-examined on 27/2016. However, the petitioner had filed petition number 734/2017 on 5/5/2017, that is almost after 1 year, to allow her to file additional evidence of PW2 and 3. The learned trial court appears to have not considered that in their cross-examination, both PW2 and PW3 had made specific admission to the effect that they had not identified and exhibited the signatures of the testator, Sewali Datta, and that they had also specifically admitted that nowhere in their evidence and affidavit they had written that they had seen the testator signing on the will, and that thereafter they had signed the will in the presence of the testator. Under such circumstances, the court is compelled to accept the submissions made by the learned counsel for the petitioner that by allowing additional evidence of PW2 and 3 to be brought on record, the lacuna which was exposed during cross-examination of PW2 and 3 would be filled up. Then your lordship has discussed regarding section 63C, my lord, in paragraph number 9, to prove a will, the sole purpose of examining the attesting witness is to prove the execution of a will, which is required by law to be attested, which is in consonance with the provisions of section 68 of the Evidence Act 1872, as well as to prove due execution of the will as per the requirement of section 63C of the Succession Act 1925. It is no longer res integra that the prescriptions as provided under section 63 of the Succession Act 1925 for proving a valid execution of a will is mandatory. As such, a will has to be proved in accordance with section 63 of the Succession Act, as well as in accordance with section 68 and section 71 of the Evidence Act 1872. In the present case in hand, the evidence of PW2 and 3 does not evince animus testandi, meaning intention of making a will or testamentary intention. As such, in the absence of any statement in the evidence and affidavit by PW2 and 3 regarding animus testandi, the essential ingredient of section 63C of the Succession Act 1925 is found to be absent, and the testimony of the said PW2 and 3 appears to fall short of the probative content to construe a valid attestation of the will. If one needs an authority on the said point, one may refer to the case of Jagdish Chand Sharma versus Narayan Singh Saini, dead through his LRs, 2015 8 SCC 615. Thereafter, this, my lord, this paragraph number 11. The learned trial court had also failed to consider that after the lacuna in the evidence of TW 2 and 3 was exposed in course of cross-examination by the learned counsel for the petitioner, if the respondent number 1 is permitted to give additional evidence of PW 2 and 3 to prove the signatures of the testator in the will, the effect of cross-examination of the said witnesses would be washed away, which would surely prejudice the petitioner. So, my lord, the submission of the learned senior counsel, that let the matter be sent back, let it be heard, my lord. This cannot come in, my lord, because what they had done after PW 2 and 3 were cross-examined, my lord, then their evidence were closed and we were called upon to file the evidence of DW. That we did, my lord. Thereafter, they changed the counsel and then filed this petition and put the blame on the counsel that the counsel did not exhibit it. Exhibit the will, my lord, through PW 2 and 3, my lord. The entire burden was put on the counsel, my lord.
No, that is true because the council will only know how to exhibit, what to exhibit.
Yes.
That is
Okay,
something we'll have
if we
to,
leave aside that part.
that we'll have to accept. That's why I pose that query. Section of trial court lawyers will not know the procedure.
If we leave aside that exhibiting part, my lord, also, but nothing precluded them from stating in terms of section 63C, my lord, of the Indian Succession Act. That is the only thing, my lord, the attesting witness is to state. That was not stated, my lord, and that was exposed during cross-examination, my lord. Now, after a lapse of 1 year, my lord, they change the counsel and say that it is the fault of the advocate, my lord. If such a procedure is accepted, my lord, then there will be no end to a case, my lord. Because in your lordship's order at para 12, your lordship has dealt that part by relying upon the Supreme Court's judgment reported in the year 2009 for SCC 400. But that no case was made out to allow them to file any additional evidence or to recall the PW 2 and 3.
Okay.
So, my lord, I pray that the review application may be dismissed.
And just in 3 was replying. The first submission, my apparently it's a mistake committed by the lawyer. And possibly I can go to the extent of submitting that the respondent is actually trying to get a walkover because of the mistake committed by the lawyer. Yes, my lord. This is my submission, your lordship may record it. This whether your lordship will permit when your lordship is dealing with the power of the court to be exercised in 151. Secondly, my lord, review jurisdiction which they are saying that 1990 Supreme Court they have really possibly there that in Mira Bhanjo's case of 1995 Supreme Court has been relied on. There, I think it was said that unless by apparently showing the error and by a long reasoning, if you want to show something that is not within the jurisdiction of the order of 71. And here is a case, my lord, somehow the almost Supreme Court has did not take the trouble of deciding the matter and say that you file an application for review. Now, possibly to some extent, that burden on us to show that it still falls the examination that I am requiring our lordships to do falls within the four corners of order petition rule 1 can be reduced. That burden on me can be reduced to some extent that since the Honorable Supreme Court is setting forward and filing the application for review on 2 counts. First submission was I'll deal with that now, my lord. And second was that it was a mistake on the part of the council. Supreme Court was very clear, my lord. Lordship will kindly see. In the page 85, my lord. He further submits page 85, bottom paragraph. He further submits that all that the trial court did was to permit the petitioner to give a mark to the signature where the testator had signed, as the testimony of the attesting witnesses had already supported the execution of the will. The deficiency being only stated to be an error of the council. There's the second part. So to that extent, madam, my humble submission before lordship will be that rigor of establishing that it still falls within the four corners of order petition rule 1 can be said to have been reduced to some extent, my lord. And thirdly, my lord, when you file a review application, it's very difficult to say that the judgment passed by lordship is erroneous, did not take into consideration these, that. Why we put it in our own language, depending on the command one has over his language. But fact remains that what I submitted is in respect of the findings recorded by your lordship, which my learned friend has just now read, and particularly in paragraph 12 and 13, where your lordship has held that no, it was a lacuna. So my submission before lordship is the court below did not take into consideration the factors which I have said from paragraph 19 of the judgment of KK Velusamy. For that, possibly your lordship can always send it back, not allowing my petition, but directing the court below to consider this application in the light of these parameters written by the Honorable Supreme Court. And lastly, my lord, about the notice, my lord, in the present petition we have said he is a man of 74 years. He has got no connection with the daughter, who is the petitioner. She is a working lady and he is an old man. What he says, we have stated all this in paragraph 3 of our revision petition. He might have received, but he did not ever serve this copy to the petitioner. That is my submission. Lords will consider.
Paragraph 3, you said.
My lord?
Paragraph 3.
My paragraph 3. Page 11, my of my review petition. Yes. This paragraph 3 I've stated, and there is no denial of this by filing any objection to this revision petition. That's all.
Okay.
That judgment I have not brought today. Tomorrow in the morning,
Which one?
that if the will of the testator should be given due weightage.
I have one small correction, my lord. Your lordship permits.
Just a moment. Okay, then
My lord,
close the
No,
matter.
one correction, my
deeply
lord.
obliged.
The submission that is made, that only thing what the trial court had permitted was to exhibit the signatures of the testator. It was not that, my lord, because the prayer that was made in the petition filed under 151 was to only allow the PW 2 and 3 to file additional evidence, only to exhibit the will,
Where is
not
that?
to
Which page?
page number 68. ma'am. Because again, thereafter, another application will come that mistake was committed by this set of counsel also. So
Please
let us
repeat your
speak here
submission
on this.
again.
Page number
Please,
68
page 68, yes.
in the prayer portion, my lord.
Yes.
The prayer is, it is therefore prayed that your honor would be pleased to allow this application under inherent power of this court, honorable court, and thereby allow the petitioner plaintiff to file additional evidence through PW 2 and PW 3 to exhibit the last will, dated 9/4/2008, executed by late Sivali Datta to prove the same and be pleased to pass such further or other orders as the honor think fit and proper. So there was no prayer made to exhibit the signatures, only the will. So that's why your lordship had called the records to see whether the original will was ever exhibited or not. Because in the evidence and affidavit of PW number 1, what is exhibited is the copy of the will. That your lordship will find. Imam Doctor's evidence in chief, brother. At page number 48, my lord, is the evidence and affidavit of PW number 1, Imam Doctor.
Yes, sir.
Page 48 is the evidence and affidavit of Imam Doctor, PW1, my lord. In the very next page, page 49, at the bottom part, your lordship would see a copy of the will dated 9/4/2008 is marked as Exhibit 1. And Exhibit 1 is the signature of Shri Pradeep Burman. Exhibit 1-2 is the signature of Telam Rachi. And so your lordship had called for the records to see whether the original will was exhibited or not. Because here they have exhibited the copy of the will.
And where is that order to send it in safe custody?
6th of December 2017. madam. Second paragraph. Second paragraph, concluding paragraph. madam.
Mr. Mukit, Mr. Mazumdar is right. Whatever I do is in the order is how I deal with the matter is a different aspect altogether.
My lord.
But the lawyer did commit a mistake. This is a blunder. He does not know.
Yes.
This is a trial.
Regarding the technical part of exhibiting, I understand, my lord. That I
No, I
can,
mean that
I
part.
can also
Otherwise,
say.
Mr. Mazumdar would
But
not have been
regarding-
here.
Kindly, your lordship may appreciate this, my lord. What is the role of the attesting witness, my lord? Only to say that the testator had signed the will in his
No, but that
presence
is
and he
something
had
which
signed
you see,
the will as attesting
if-
witness. Only
if-
that much, my lord. Rest is not required, my lord.
if a litigant engages a counsel, this is an assistance he would expect from a counsel.
Minimum.
And Mr. Mazumdar is right in demonstrating the counsel made a blunder in this case.
Just think, my lord, before the amendment of 2002, my lord, where the chief was also taken orally, my lord, what would the witnesses would have come and said? Only this part, my lord. Only 2 lines is required from the attesting witness. Even that is not there, my lord. Exhibiting
no.
part I can understand, my lord.
Mr. Mukit, you see, there's a question which we are now dealing with. You see, I'll give you an example. Something is written in the plaint. Correct. Now, in the evidence on affidavit, the same thing is reiterated. Does it become an evidence?
Well, now that is the trend, my lord, after 2002, my lord.
The question of trend is something else. But what would be an evidence? An evidence would be a statement made by the witness on his own volition
Yes.
in a matter.
Yes, ma'am.
But now, once this has started and it's become a practice, Mr. Mazumdar is right in saying that the law who was conducting the matter in the trial court was absolutely.
But it is a very dangerous thing, my lord. Then there will be no end to the case, ma'am. Today, if this is entertained, then I do have a
You
scope.
see,
in
we are
future
not
also, ma'am.
concerned with the ripple effect which the orders would have. You see, dangerous thing you are saying, let us say an armed person has done a mischief, we are granting him bail. Correct. So we are not concerned with the ripple effect which will be happening. We are looking at a case as dispassionately as we should and deal with the matter in accordance with law. Correct.
My
If
lord,
I-
your
if I
lordship
start-
has already
if I start
held
appreciating-
that if this is allowed, then how the defendant in the case would be prejudiced. That
No, that is
circumstances is
something else.
already
And what I'm
spelled out,
trying
my
to
lord.
say. You see, that is not what I'm saying. How I deal with the matter is something else.
Yes.
But what is real in reality, which is happening is when somebody relies on a uniformed man.
Reality is there, my lord, but then we are case specific and then we argue according to the case, my lord.
In this, I think I'm in same page with Mr. Mazumdar. Or has done a blunder.
But this petition was filed after the DWs were filed.
Okay. I'll pass orders today. We may get it
Fine.
tomorrow. Just a moment. I'll did the facts, otherwise I'll forget. एक मिनट. But Mr. D. Mazumdar, London Senior Counsel, assisted by Mr. P. Baral and counsel for the petitioner, as well as Mr. Z. Bukit, London Counsel, appearing for respondent number 1. Nobody is appearing for 2.
Pro forma. Pro forma. Father who received the notice.
Okay, none appears on call for respondent number 2. Although notice on the said respondent deemed to be duly served. Next paragraph. This review petition under order 47 rule 1 read with section 114 CPC is directed against the judgment and order dated 13/3/2020 passed by this court in CRPIO 396 of 2017. Next paragraph. The proceedings before the trial court, i.e. the Court of Learned District Judge, Kamrup Metro, is the proceedings of probate title suit number 1 of 2015 full stop. The pleadings before the learned trial court being not relevant to adjudicate this review petition has not been adverted to. Full stop. It was suffice to mention that the testatrix, namely Sewali Datta, SEWALI, sorry, in bracket, since deceased, bracket close, had executed her last will dated 9/4/2008, thereby bequeathing the ground floor of a multi-storied building consisting of 5 floors to the review petitioner. Full stop. It may be mentioned that the respondent number 1 is the surviving son of the testatrix. Son, right? Mr. Mokit, he's a son. Respondent number 1 is the son
Son of Sewali Datta,
of testatrix.
Testatrix one.
And the pro forma respondent number 2 is the husband of the testatrix. Husband,
Another son.
another son. Okay, another son.
And petitioner is the daughter
And
of,
and the petitioner is the daughter of the pro forma respondent number 2. Full stop. Full stop. The testatrix died on 10/7/2009. Full stop. Thereafter, the petitioner approached the learned trial court by filing a petition under section 276 of the Succession Act, which was registered as misprobate case number 14 of 2014. Full stop. On contest, the proceedings was denumbered as probate TS number 1 of 2015. Full stop. In the trial court, the petitioner along with PW 2 and 3 had filed their evidence on affidavit, and they were cross-examined and discharged. And thereafter, the respondent number 1 had filed his affidavit in evidence on affidavit, right? Thereafter, on 5/5/2017, the petitioner had filed a petition under section 151 CPC, registered as petition number 734 of 2017, with a prayer to allow her to allow the petitioner to file additional evidence on affidavit of PW 2 and 3 to exhibit the last will dated 9/4/2008, executed by the testatrix, to prove the same. The said petition number 734 of 2017 was allowed by the Learned District Judge Guwahati by order dated 25/9/2017, on cost of rupees 2,000, and it was provided that the additional evidence on affidavit would be filed in respect of both the PW 2 and 3 on 15/11/2017, failing which no further date would be given. The aggrieved respondent number 1 herein approached this court by filing CRP IO 396 of 2017 against the said order dated 25/9/2017. Stop. As none appeared on call for the respondents in CRPIO 396 of 2017, this court by order dated 13/3/2020 allowed the revision and interfered with the order dated 25/9/2017, which was set aside and quashed. And it was also provided that if any additional evidence on affidavit was filed by PW 2 and 3, the same would be treated as expunged. Full stop. Next paragraph. The petitioner being aggrieved by the said order dated 13/3/2020 in CRPIO 396 of 2017, had approached the Supreme Court of India by filing a special leave to appeal within bracket C number NO within bracket S 20040 of 2021. And the following order was passed on 13/3/2020, page 85-86. Next paragraph. Consequent to the present, review petition has been filed. Next paragraph. The learned senior counsel for the petitioner has submitted that the PW's PW numbers 2 and 3 had deposed to the effect that had deposed in their evidence on affidavit that the testatrix had executed a will in their presence. Which was in consonance with the provisions of section 63 within bracket 3 of the 63(3) of the Evidence Act.
Indian Succession,
Evidence Act.
Indian Succession, 63C of Indian Succession Act,
The Succession Act.
1924.
So, however, the omission on part of the learned counsel for the petitioner was that the signature was not exhibited. And although the evidence of the testatrix executing will in their presence could not be demolished in cross-examination, but for the absence of proving the will along with the signatures, the purpose of giving evidence of the witnesses was not achieved. So it is submitted that it is a well-settled legal proposition that the wishes of the testatrix has to be honored and given due weightage. And in this regard, the learned senior counsel for the petitioner has referred to the case of so and so. First off, it is submitted that when the petitioner had approached the Supreme Court of India, he was not aware, the petitioner was not aware that the notice to her was served on her father, i.e. the respondent number 2, proposed respondent number 2. However, in this petition, it is, but it is submitted that in this petition, it has been explained that the father of the petitioner, being a senior citizen, though received the notice, failed to hand it over to the petitioner. First of all, it is submitted at the bar that the performer respondent number 2 is presently 74 years of age. Next, it is further submitted that the court is required to consider whether the application for additional evidence is bona fide and in the interest of justice. And secondly, whether by allowing additional evidence to come on record, the said process would assist the court by getting clarification from the PWs 2 and 3. It is emphatically submitted that the issue of marking a document as exhibit and exhibiting the signatures is purely the job of a lawyer, and that in this case, the conducting lawyers had committed a mistake of exhibiting the will as well as the signature of the attesting witnesses, i.e. PW 2 and 3. Although the original will had been produced before the learned trial court, and the same was sent to be kept in safe custody by order dated 6/2/2017. So accordingly, comment is submitted that the purpose of filing the petition for additional evidence was neither frivolous nor to fill up the lacuna, but to rectify the negligence of their learned counsel by whose omission the will was not exhibited and the signatures of the attesting witnesses, i.e. PW 2 and 3, were not exhibited. Next paragraph. In support of his submissions, the learned senior counsel for the petitioner has also referred to the case of Parsion Devi, PARSION Devi, 1997 8 SCC 715. This is the one. This is two. Number 2, KK Velusamy, VELUSAMY versus N Palanisamy, 2011 11 SCC 275. The second case here. Apart from relying on the case referred herein before. Next paragraph. Oh, Parsion Devi, you have given.
It goes against him.
No, not him. He's relying on Mr. Mazumdar is relying on
2011 SS.
11 SEC 275, only that one, only one. Next one, referring to the case of Parsio Devi, that's 97 8 SEC will come here. 715. Now the learned counsel for the respondent number 1 has submitted that in order to entertain a review application, or the same must be within the parameters of mistake or error apparent on the face of record. So it is submitted that from the submissions made by the learned counsel for the senior counsel for the petitioner, it would be apparent that it is apparent that the present case falls within the domain of erroneous decision, which cannot be corrected in excesses of review jurisdiction. It is further submitted that from the order of the Supreme Court of India dated 13/3/2020, passed in SLP Civil, SLP within bracket C, number 20040 of 2021, the 2 submissions of the counsel for the petitioner was number A, that all that the trial court did was to permit the petitioner to give a mark to the signature where the testator had signed. As the testimony of attesting witnesses had already supported the execution of the will. Comment number B, that the deficiency was only an error of the counsel. So it is something that both the points taken before the Supreme Court of India, as recorded in the order dated 13/3/2020, is not sustainable on facts, because as per the contents of the evidence on affidavit of PW 2 and 3, only a copy of the will was exhibited and not the original will. Which is also reflected in the contents of petition number 734 of 2017, dated 5/5/17, where a prayer is made to allow the petitioner to file additional evidence through PWs 2 and 3 to exhibit the last will, dated 9/4/2008. Hence, comment is submitted that clearly by alleging that a mistake has been committed by the learned counsel for the petitioner, same would not constitute a good ground for exercising jurisdiction of review under Order 47 rule one read with section 114 CPC. Okay, that's all.
My lord, the Supreme Court's order date is 11/12/2021. That may kindly be corrected. Supreme Court's order, page 85. Order date is 11/12/2025, 21, and not 13/3/2020. 13/3 is your lordship's order.
Okay, this order is 11/12/21. All right.
11/12,
11/12/21 Supreme Court order,
Supreme
not
Court.
13/3/2020.
13/3 is your lordship's order.
Okay. 11/12/2021. Okay. I'll just examine the recording chamber and pass orders.
Deep blue.
There may be some delay in uploading. May get it tomorrow evening, not tomorrow morning. Other matters will be rolled over. If there is any interim order to be extended, please tell the court master. Ask the technical team to correct it.